Reason bench item 1 with 2 for hearing.
Mr. Banerjee,
Yes, sir.
in fact, we don't need a hearing, but there was a default since we couldn't finish the delivery of the orders within the prescribed time.
Yes, sir.
So we fix it for a formal hearing so that we can close it and then deliver the orders within time.
We were a little concerned. We didn't realize what was the very well, whatever.
You understand the position because
Yes,
unless
yes,
we
yes.
do it within the time, then there's a default on our part.
Yes.
Therefore, we wish to put the record straight.
Very well.
I was thinking if there is any query from your lordships.
No, in fact, we have none. It's just because that the normal period is over.
My lord.
We
My
just-
lord, your lordship indicated my Honorable Justice Saikia was in a PSC matter bench earlier. So there are reasons, my lord.
So this way.
Well,
Lordship may fix any other date if necessary. Some clarification we can always, my lord.
no, my lord.
Have
My
any.
lord, my lord don't need clarification. It's just so formally, my lord, hearing is closed today.
Huh. We just say that the matter has been reheard and
Yes, yes.
Yes, lordship can always.
heard Mr. R. Banerjee, learned senior counsel, assisted by Mr. D.
Ian Sharma, my lord.
D. H. Sharma.
A. Basu, my lord. Mr. A.
Please
Saiwan.
give the names.
Yes, my lord, will give.
Learned counsel for the appellant in Company Appeal 4/2016. Kamal was the respondent number 1 in the connected Company Appeal 3/2016. Also heard Mr. D. Mazumdar, learned senior counsel, assisted by Mr. B. Quashing, learned counsel for the respondent in private respondent in Company Appeal 4/2016. Who's the appellant in Company Appeal 3/2016?
Yes, we are in 3, my lord, yes.
Oh, CGC is there? Okay. Mr. MR Adhikari, CGC appears for the Union of India in Company Appeal 4/2016. Have we left out anyone? No. Mr. J. Roy.
This,
Huh? Other side. J. Roy was also there? No. Okay. Okay. Clarificatory hearing is concluded. It has been reserved.
Man.
so grateful.
Oblige, lordship.
You suffered some inadvertent travel.
No, it's always always a pleasure, my lord, to be here, my lord.
I beg to mention for listing to WPC criminal matter. One matter is expertise without serving.
Listing, whatever you do it today. No, nothing for tomorrow.
And then today after completion of.
Do whatever, if you can bring it today. Nothing for tomorrow.
Yes, obliged.
Give all the mention memos to the court master.
Yes.
Except for motion, I don't think anything else can be listed. Give it to the court master, all the players for listing.
My lord, I have prayer in item 30, my lord.
Item number
30.
Yes.
This matter may kindly be updated, my lord. This was listed on last Monday, my lord. But something is missing in the order, my lord.
Correction.
Yes,
Okay.
I'm deeply obliged.
Lordship, I'm putting a date after vacation, Your Lordship, for admission, Your Lordship. One matter.
Don't make a mention right today. If it is for after vacation, please make it on the reopening.
May I please, your lordship? I beg to mention item number 17, lordship. Method will be updated, lordship. After motion, lordship.
17.
17, lordship.
Okay.
Deeply obliged.
Item number 20, if some correction, correction.
Corrections. Okay.
Much.
Except for the name of the parties. Yes, item 1.
Item 1 for motion.
Mr. Adhikari.
I have not received any instructions, but my lord, on Monday, my lord, my friend informed me that according to his brother, my lord, the petitioner has reached his home. This is what he told me. And on Monday, I have communicated the order on
Let-
Tuesday only.
we fixed after vacation in the meantime.
Yes,
this is
yes.
gone. Mr. D.K. Agarwala, then counsel for the petitioner, submits that. As per information received by him, the petitioner has already reached his home. Next one. Mr. M.R. Adhikari and the CEC has submitted that although he has communicated the order dated 26/20/25 to the authorities, he has not received any instructions. Be that as it may. Notwithstanding that the learned counsel for the petitioner has information that the petitioner has reached home. Awaiting instructions from the central government, the matter is adjourned today as per list on 16/7/2025.
Right.
Item 2.
May please, your lordship. My lord, here in this case, my lord, the petitioner has been declared foreigner by ex parte order. Lordship will find ex parte order at page 19. The relevant portion at page 20, paragraph 2 is important. My lord. Notice was served on the Gabura house, my lord. On the notice board of the Gabura, not my residence, my lord. I am a pharmacist serving under the government, my lord.
Okay, we'll call for the records.
My lord.
Bail will be considered on receipt of records.
My lord, I may be protected, my lord, by interim order. I am a government servant, my lord.
Opinion of page 19,
My lord.
9/9/24.
Yes, my lord.
Okay. Let me. Here we are giving bail, huh? Mr. A.R. Sigdat, learned counsel for the petitioner. All the respondents are there. Opinion is at page 19, dated 9/9/2024. Passed by so and so in case number so and so, RFT case number so and so. It's the ex parte opinion, huh? We were declaring the petitioner to be a foreigner of post 25 to 1973. Next, the learned counsel for the petitioner submitted that the petitioner is a pharmacist in a government hospital and that the notice was not served at his residence, but at the notice board of the Gambura. Next, issue notice returnable in 4 weeks. Extra copies in course of the day. Call for the relevant records of the concerned tribunal. The prayer for bail is opposed by the learned standing counsel for the FT matters. Considering the prosecution, 10 days time to take bail of rupees 5,000 to the satisfaction of SP border.
SP Borpata,
Borpeta. Okay.
deep level.
Item 3,
Wait, please, Your Lordship.
Yes, opinion at page.
Page 57, Your Lordship. The impugned opinion was passed on 9/5/23, Your Lordship.
You have to wait for some time for bail.
Your Lordship, thereafter he has filed a review petition, but since it was filed at a delayed stage, Your Lordship, it was not filed within the limitation period, Your Lordship.
Pardon me?
Your Lordship, thereafter he has filed a review petition, Your
Where is
Lordship.
that?
Page 76, Your Lordship.
76.
Yes, Your Lord. Since it was filed at a late stage, Your Lordship, and it was not filed within the period of limitation, Your Lordship, so it was.
7/4/25.
Yes, Your.
But there was a delay,
Yes, Your. Lordship.
rightly not entered in.
Yes, Your Lordship. We had filed I had filed a review petition along with the delay condonation petition also, Your Lordship. So, but it was rejected, Your Lordship.
Okay. Mohammed I Ali, Hussain, learned counsel for the petitioner. Mohammed I Hussain, learned counsel for the petitioner. All the respondents are there. Opinion at page 57. Dated 9/5/2023. Passed by so and so in FT8 case number so and so, reference case number so and so. By declaring the petitioner to be a foreigner post 25 to 1971 stream. Next, by the learned counsel for the petitioner submitted that along with the application for condonation of delay, a review petition was filed by the petitioner. And the prayer for delay, condonation of delay was rejected by order dated 7/4/2025. And consequently, the review petition was also dismissed. Therefore, the order passed in the reference case as well as in order dated 7/4/2025, passed in this case number 1 of 2025 are assailed in this petition. Notice extra copies within 2 days. Call for the records. Bail is opposed by the learned standing counsel for the FT matters. Bail of rupees 5,000, 10 days time to satisfaction of
Your Lordship, SP border Sunitpur.
SP borders, Sonitpur, Tejpur.
item 4,
May I please, Your Lordship?
Yes.
Impugned order page 74, my lord.
Page
74, my lord.
2019.
Yes, my lord.
Third. Mr. A. H.M.R. Chaudhary, General Counsel for the petitioner. The respondents are there. Opinion at page 74, dated 15/3/2019, passed by so-and-so in case number so-and-so, corresponding to police case number so-and-so, by which the petitioner was declared to be a foreigner post 25/3/1971 stream. Next paragraph. In view of inordinate delay in challenging the impugned opinion, keeping the issue of maintainability open, issue notice returnable on 37/2025. Extra copies in course of the day. Let the relevant records be requisitioned from the concerned tribunal. The bearer for bail shall be considered on receipt of records. List on 37/2025.
Item 5.
May please, your lordship.
Item 5,
Yes, lordship. Including opponent is please 103.
page number
103. 103.
103.
3.
Okay. Mr. F.A. Hassan, General Counsel for the petitioner. Respondents are there. Page 103, opinion dated 27/3/2025. Passed by so-and-so in reference. In case number so-and-so, reference number so-and-so, declaring the petitioner to be a foreigner post 25/3/1971 stream. Notice returnable in 4 weeks, extra copies in course of the day. Let the relevant records be requisitioned from the concerned tribunal. The prayer for bail is opposed by the Learned Standing Counsel for the FD matters. Bail of rupees 5,000, 10 days time to take bail of rupees 5,000 to the satisfaction of
Sonitpur.
SP border, Sonitpur, page 4.
My lord, on humble request, my lord, there is some mistake in our type of my lord. The same may be correction, my lord. I may be allowed to some corrected, my lord.
Where there is a correction?
My lord, please 79 type copy, 79, 80, 81, my lord. No type copy, my lord.
Okay. Before the last date, deletion on so-and-so, we say, Learned Counsel for the petitioner pays for leave to substitute type copy of annexure 17, which contains some typographical error. So, prayer is allowed. The a freshly typed copy of annexure 17 be handed over to the AOJFT section to be made a part of record
Yes.
as page.
Please, not my card. 79 to 81.
79 to 81, and the existing pages 79 to 81 shall be struck out, struck off. So, however, it shall be retained on record as page 81A, 81B, and 81C respectively.
Yes.
Strike out with red pen.
Okay, very good. Yes.
That will remain on record.
Yes,
We'll
yes.
have to insert a new one.
Yes.
Item 6.
May I please, your lordship? My lord, the opinion at page 188, my lord. Opinion dated, my lord, 20/03/2025.
Or the age study, it's very good. Tribunal, tribunal Roman at the
S. A. Ahmed and counsel for the petitioner. Response are there. Page 188. Opinion dated. Twenty-three, 2025. Passed by so-and-so in FT case number so-and-so. Corresponding to IMDT case number, it is in paragraph 1, huh? Corresponding to IMDT case number so-and-so. I have underlined that. Thereby declaring the petition to be a foreigner of post 25/3/1971 stream. Notice returnable in 4 weeks, call for the extra copy in course of the day. Call for the records. If prayer for bail is opposed by the understanding counsel for the FT matters. 10 days time to take bail of ₹5,000 to the satisfaction of
SP border, Borpeta.
SP border Borpeta. Okay. Extra copies in course of the day.
Obligement.
Item 7.
Yes. Opinion at page.
Lordship, in this case, my lord, earlier, my elder brother was declared foreigner and in connection with the FT case number 502/2017. And he.
Where is the opinion? We don't have time today. If you want to argue, we'll take it up in the last item. Where is the opinion?
Opinion, my lord, page 24. My lord.
Today, if you want to argue, you will take consent of all the learned counsel present here. I'll be very happy to take up your hearing. Take the consent.
Not next.
And take the consent outside, so they can, if they want to use their hands, they can do it. Not inside. Okay, Mr. K. Bhunyat and counsel for the petitioner. Opinion, response are there. Opinion at page 25, dated 16/5/2025. Passed by so-and-so in FT case number so-and-so, corresponding to R case number so-and-so. Thereby declaring the petition to be a foreigner post 25/3/1971 stream. Notice extra copies in course of the day. Call for the relevant records. Prayer for bail is opposed by the learned standing counsel for the FT matters. Bail, 10 days time to take bail of ₹5,000 to the satisfaction of
SP for whatever.
SP border.
He's inside, my lord.
Huh?
He's inside.
Oh, he's been taken into custody.
Yes.
Where is that?
He is my lord, last page in the order. The time of pronouncement of the order. Page 36.
Page.
No. Page. My lordship, 46.
Which page?
Page, my lord.
Okay, where is the statement given in your writ petition?
45 and 46.
Which paragraph in your petition you have said that he's been apprehended?
Paragraph, my lord, second, my lord, 3 paragraph 3.
3. You don't know, here you write. Para 3.
Petitioner has been declared foreigner solely based on final opinion dated so and so on whims, and the petitioner has taken custody prior to passing the said in final order in violation of principle.
Where is the statement that he is taken into custody?
Yes, my lord.
Where is it? Which line?
On the same date.
Where is the statement? I am asking you a question for the third or fourth time.
Paragraph 3, my lord.
I am there at paragraph 3. You can please count the line and tell me. Okay, last item. Call as the last
Taking
item.
into custody, my lord, I have taken.
Please tell us, you are spending so much of time. We will take it up as the last matter today before rising. Today we don't have time. Please try to understand. We have been telling you not to spend time today. Time others are also very slow.
On
I
sixth line,
can't.
on sixth line, my lord, there is a statement.
Sixth line.
Yes.
That's right. So as simple a question as that, you are taking so much of
Yes.
time.
Based on final opinion, order dated.
After that, even good things you say doesn't sound good here.
I have narrated, my lord, on whims and the
Sixth
petitioner.
line, the present petitioner has been declared foreigner solely on whims and fancies and is taken into custody prior to passing of the final opinion. What is this?
May come to the page for now, my lord, 46, my lord.
40?
It's 46.
6.
Yes, Lord. Opinion, my lord. In view of the above finding and a discussion, the tribunal is of the opinion that OP so and so is foreigner and illegal migrant and enter into on or if after so and so, hence reference case is answered in affirmative and in favor of the upon delivery of final opinion in the open tribunal, AG have acted swiftly that help of the border police. Kassimir was arrested and taken the custody from this tribunal to detain him in transit camp as per law. So already
On the
taken
same day,
custody, then pass the order. On the same day.
some same. 64.
It will not be a, it will not be bail. It says, then you say that you should notice, return over, give a fixed date, 30/7/2025. The relevant records be requisitioned from the learned tribunal by regular usual process as well as by email to the following email address of the learned tribunal. Next para. The prayer for bail shall be considered on receipt of records. Next para. However, it is provided that the petitioner, namely,
Asad Mia.
there are two more aliases, Tasir Mia, alias Tasir Mia, alias Aven Mia. We take this name from page 6. Shall not be deported out of the country without order of the court. Next para. The petitioner shall produce the certified copy of the order before the superintendent of police, border. Which place? Borbetta.
Got it. My lord, your lordship has
Bring
passed
this to the notice of this said authority. Yes,
not to be deported if not deported already.
Okay.
First.
not to be deported if not already deported. Okay.
Lordship. Hi, Lord.
We're giving a fixed date.
Lordship.
We understand.
Obliged.
Item 8.
Page 18, my lord, impugned order. The date is mentioned in page 19.
Page
Page 18, impugned order. The next page is, the date is mentioned, 19/2/2022.
19/2/22. Okay, we'll have to wait for bail for some
My
time.
lord.
But Mr. A.W. Haman, learned counsel for the petitioner. All the respondents are there. Opinion dated 19/2/2022. Passed by so-and-so in case number so-and-so corresponding to our case number so-and-so, declaring the petitioner to be a foreigner post 25 to 1971 street. Notice returnable on 30/7/2025. Call for the records. By the usual process as well as by email to the following email address of the concerned court, concerned tribunal. Next, the prayer for bail shall be considered on receipt of records. Okay. As an interim measure until the next returnable date, comma, the petitioner, namely so-and-so, shall not be deported out of the country without order of the court. The hero said, shall not deport out of the country. He has not been apprehended.
No, no, yes.
Okay. Out of the country without, in the event the petitioner is, namely so-and-so is apprehended, shall not be deported out of the country without order of the court.
Grateful, my lord.
Item 9.
May I please, Lord? Page 29, ex parte order, Lordship.
29.
Yes, Lordship. Notice was served upon the wife of the petitioner, Lordship, and at that time the petitioner was in Bihar, working in a brick factory, Lordship. Now, Lordship, from the
We have
LBO
to wait for
report,
some time for bail.
Lordship, from the LBO report, Lordship, inquiry officer opined that he is not.
Today I'm sorry, we are not hearing on merit. We can't.
Yes.
Mr. S. Alam, General Counsel of the petitioner. All the respondents are there. Page 29, opinion dated 10/11/2023. Passed by so-and-so in FT case number so-and-so, within bracket, reference case number so-and-so. Thereby declaring the petitioner to be a foreigner of post 25/3/1971 stream. Notice. Extra copies in course of the day, call for the records. The notice made it return on 30/7/2025. The records. The prayer for bail shall be considered on receipt of records. Next, in the meantime, the petitioner, namely so-and-so, is apprehended, shall not be deported out of the country without order of the court. Okay.
Item 10,
My lord, page 30 is the opinion.
30.
Division.
We'll have to wait for some time for bail till we get the records.
But my lord, finding
You-
of the completely wrong. I regularly appearing in the court. But he said
We
I am
don't know,
not
but the thumb rule of 1 year is crossed.
because my lord,
Thumb rule of 1 year is crossed.
yes, my lord, that is there. But
Uh,
I waiting for judgment, but several date has been fixed by the, I paragraph 6 is lost, kindly see. Paragraph 6 I have mentioned, my lord.
So that we don't know. We'll have to
And
wait
the
for some time.
water copies are also there.
Where is it?
Yes, it is.
Page?
Yeah, right. From the beginning, I obtained all the orders copy, my lord. And I clearly mentioned in paragraph 6 of my petitions. First order dated 26/7/16. I filed evidence. I'm regularly appearing. Matter was fixed for argument, but several date has been given by the court itself, my lord. Now they find that I have been not cross-examined. I am not appearing in the court, my lord. From the argument stage, it is adjourning by the court.
Mr. Ahmed, you could have saved so much of time to
Fine.
to give a statement here and produce the document. Now you have to read the documents.
Yes.
you 23 into 33. Is I think 22. The criminal work is. So common from my siding, I don't know it to put your holding. If 21 into Paris will do. Not item 21, yet it's craft no start with it, use item. Yes.
Mr. Pine, we are giving bail to the petitioner. 7 years, the judgment was not, the opinion was not delivered. It's made out a case.
Yes, but I don't know whether because it is not filed. I could not go through.
No, there's same thing here.
Yeah, I give.
No issue, my lord, your lordship may grant, your lordship is calling for the record also.
No, you just satisfy yourself first.
Yes.
We'll take it after some time. Let him go through it. We'll pass orders at the later stage. Let him go through it. Yes, item 11. Yes.
Already at page 42.
Page number
42.
42. We need to wait for some time for bail. Mr. H. Rana and counsel for the petitioner. The respondents are there. Opinion dated 23/11/2023. Passed by so and so in FT case number so and so, police case number so and so. They were declaring the petitioner to be a foreigner post 25/3/1971 stream. Notice return of around 37/2025. Extra copies in course of the day. With the relevant records with requisition from the concerned tribunal. The usual process as well as by following email address of the said learned tribunal. Next paragraph, the prayer for bail shall be considered on receipt of records. Next paragraph, in the meanwhile, if the petitioner, namely Muhammad Rafiqul Ali, alias Rafiqul Islam, is apprehended. Take the spelling from page page 2, constantly. So it's apprehended, it shall not be deported out of the country without order of the court.
Supplementary item 19.
Yes, did you get the information?
My lord, in this case, my lord, the person has been handed over to BSF sector headquarter, Uburi, on 26/05/2025.
Okay, just a moment. Please write this, Border Security Force.
BSF sector headquarter, Panbari, Dhupuri, my lord.
Sector
On 26/5.
Mr. Adhikari, we'll request you to get the information.
I'll provide this later.
And Mr. AHMR Chaudhary, and counsel for the petitioner. Which also heard, all the respondents are there. Next paragraph, pursuant to order dated 24/6/2025, Mr. J. Pang, and counsel for the FT matters has submitted that as per instructions provided to him, the petitioner, namely the husband of the petitioner, namely
Rahomal.
Raham, R-A-H-A-M, Raham Ali, was declared to be a foreigner by opinion dated 1/7/2010, passed by the learned member, Foreigners Tribunal, Nagaon, in FT case number 825/2007, was apprehended by the border police, was handed over to the border security force, on
26/5/2025.
Next para. Accordingly, we request Mr. M.R. Adhikari and CGC to obtain instructions as regards the whereabouts of the said declared foreign national. Can we get it tomorrow? Make an attempt. Next para, as the list on, make it 27/6/2025. We'll try to upload it as early as possible. Type this in priority.
Item 20.
Type this in priority. This,
662. My lord, this is also handed over, my lord, on 26/5/2025 to 183 Battalion Tura.
just. Yes, please.
The instruction is that on 26/5/2025, the person is handed over to BSF 183 Battalion Tura under sector headquarters Panbari Dhuburi.
If I have not been deported, please stay my deportation. My 4 brothers have been.
We can't protect you once there is a declared.
Please hear my case. It's an exceptional case. I have been condemned without hearing. We are 7 brothers. 5 have been declared Indian by a foreigner's tribunal. My brother, who has been declared foreigner by an ex parte opinion, and other 4 has been declared Indian on merits. Of course, let me exhaust my legal remedies. That's all, man.
Where is the opinion of your brother?
My brother opinion is at page 45. That is me, my lords. 45, 47, 49. That is all the 3 brothers have been declared Indian. My opinion is at page 29. My brothers who have been detained. If I may be allowed to show prima facie illegality.
But illegality means you neglected, you slept over your right. You appeared before the tribunal by filing a petition. Thereafter, you took a deep slumber.
Let's just show one prima facie illegality, my lords. I don't know how come it is missed. My lords, kindly read at page.
We don't know, but you see, I still read fables of children. There's one story of Rip Van Winkle. I regularly read that. Here is a case where the opinion is of 2005.
Yes.
And today is 2025, 20 years. It just fits in. Story of Rip Van Winkle. I hope you have read it. No. Oh,
I will definitely.
missed good things in life.
Yeah, just show one thing, my lords.
Yes.
It's page 29, my lords. During the 4th para, during ex parte hearing, the LVO Nazrul Islam for the state appears as witness. During the evidence, he deposed that on so and so, while he was working as junior engineer, and on that day during inquiry, he could meet Muhammad Karim Ali at the inquiry center, Jonia. He further deposed that on being asked, the second party failed it to submit any relevant documents in support of his Indian citizenship. He suspected the second party to be an illegal migrant. He further deposed that the second party also failed to submit any document regarding the Indian citizenship of his brother, Minhazuddin, and also for himself. As a result, LBO suspected the second party as an illegal migrant. Now, my lords, we have annexed the LBO report. Kindly come to page 25, my lords. 24, sorry. See the reference, my lords. Name of the person, Karim Ali, Minhazuddin, all the details, the annexure B of the ERO report, second page. On the reference, it is signed by annexure B, local verification report of Nazrul Islam, certificate copy of 64 Jonia, and extract copy of ER. So prima facie, at that point of time, I submitted them way back in 1998. So even if the LVO was called for, whether he was cross-examined or whether he was shown this document or not, because it's a prima facie case.
We did not get it. What you are trying to make a point? Which paragraph you are referring to at page 24?
Page 29, my lords, that during the
No,
expiry.
it's okay. Page 24, which paragraph you are showing us?
Page 24, my lords, at the end. The following documents on which the doubt has risen has also enclosed herewith.
Oh, I think you have misread this. It says the annexure B to the ERO is considered as a ground for considering the person as an illegal migrant.
Yes.
Now, Form B You must have in the meantime dealt with many Form B.
And there is a B, that is why, I mean, can you come to page 25? Next page.
Yes,
Next page, there is an entire annexer A. What are the documents that I have submitted? Local verification done by Nazrul Islam, who was cross-examined, who say that I didn't submit any document, and certificate copy
Yes.
of 64 Jonia, extract copy of ER. So at that point of time, I submitted those documents, and it has been recorded by Nazrul Islam. Kindly come to page 26, next page. Karim Ali, Jonia, Minhaj, date of birth, place of birth, Jonia, yes. Grandfather, whether the father was registered as an Indian electoral of any kind, yes. If so, CL number so and so, 51, so and so. Then next page, mother tongue Assamese, inquiry report, dialect Assamese, page 14, paragraph 14, certified copy, 1966, AR report. Then kindly come to page 28. Issued by certificate, any document relevant under the Indian Evidence Act, certificate issued by secretary, 64 number Jonia, GP certificate, so and so. So I submitted, and how come now Nazrul Islam during the he deposed before the tribunal, MDT tribunal, and say that I never deposed? And why didn't the tribunal member cross-examine him? Because he had the LVO report with him.
Is it the duty of the tribunal, my lord, to cross-examine the witnesses?
It's a question of a person's citizenship. I mean, at least would have exhibited. It's a prima facie case, and my citizenship goes away. And after that, on an ex parte hearing, after that, 4 of my brothers have been declared as an Indian. I just stay my deportation. Allow me to exhaust my remedies. That's all.
the amount of delay doesn't entitle you to any protection.
That is the first issue, my lord. 2005, during IMDT, she was.
I was also in detention. I was 4 years and 5 months. I was in jail. My brother was in jail, sorry.
My
And
lord, hold this right.
SLP is also dismissed. His SLP is admittably has been dismissed. That is at page 39. But I still have option to file review. I still have option to file curative petitions. There has been precedence in this country. Well, there is precedence. In curative petition, the court has acquitted.
That we don't know. The
But
High
this
Court
is stated
dismissed.
there.
High Court dismissed.
Your lordship cannot go into the merits. Just give me stay my deportation. Stay my deportation merits. If I have not been deported, that's all. It's a minimum thing.
You can't do it.
Prima facie case, my lords. I have no one in Bangladesh, my lords.
We don't know. Once the High Court has dismissed this and then it went to Supreme Court.
Supreme Court also discussed.
We are not on the.
Deportation, my lords. I have no harm to this country. Stay my deportation. Just allow me to exhaust my remedy.
No, once you're declared foreigner, we can't do it. It'll be contrary to this Foreigners Act.
My lords, they have submitted one last submission, my lords. They have submitted in Rajubala Das, they have filed an affidavit. The state has filed that without national verification, I can't be deported. My brother cannot be deported. Let them submit whether their national verification test has been happened or not.
That's always done.
But we cannot. That's when I am alleging.
You see, you are declared foreigner. What more? What do you want?
Let me allow me to exhaust my remedy.
Exhausted.
Only,
On merits,
only remedy is that few months down the line, there's an opportunity for you to become a lawmaker.
It is
that will be coming very soon.
It is famously said, your lordship, it is famously said that both the side knows the truth. It is the judge who is on trial.
That's what is happening here.
Yes, your lordship. Unfortunately, your lordship. Here the IMDT, they never go into the merits. They didn't go into the merits.
No.
On procedural mere technicalities, I have been declared as a foreigner.
That's opinion of 2005.
My lord, all the remedies has been exhausted by the petitioner.
What did you say?
Now, by filing these petitions after petitions, my lord, they are just dealing the
It's okay.
interviews.
Did I say anything? No. No, I did not take.
Yes,
this.
already,
Okay.
my lord, that
Heard
part is
Mr. D.K.
dictated.
Agarwal and counsel for the petitioner. Also heard of the respondents are there. Next paragraph. The pursuant to order dated 24/6/2025. The learned standing also for the FT matters is submitted that as per instructions received by him, Karim Ali alias Abdul Karim alias Karim Ali, para 2 of the last order, against whom an ex parte opinion dated 8/2/2005 was passed by the erstwhile illegal migrants within bracket determination bracket close tribunal of Barpeta in case number 2402 of oblique 03 at page 29. Which was declared to be a illegal migrant within the meaning of section 3 within bracket 1 within bracket C of the erstwhile illegal migrants within bracket determination by tribunals within bracket close Act, 1985. Upon his upon being apprehended was handed over to
BSF 183 battalion.
Border Security Force, 183 battalion.
Tura.
Battalion is BN,
BN.
Tura,
Un-
under
Sector
headquarter,
Panbari to
Panbari,
Dhuburi.
Dhubri. Next paragraph. Accordingly, we request the learned CGC to obtain information about the whereabouts of the said declared foreign national and if is already reported, the place through which the deportation has taken place. Next paragraph. This also tomorrow. This from 87. 25. Next.
Oh, look is this, huh? What's up? What's up? Hard copy get out. Declaration get here. Go to dismissal. And this backlash looks up for years.
Item 21.
For instruction.
Not your lordship. No, you took instruction.
Kali instruction, Kali instruction.
My lord, I'll get the instruction, my lord. I'll try to get to.
Item 22.
May I please lordship?
Yes.
No.
Okay, 25-5.
25-5, my lord. And there is no case pending, my lord. No reference pending, no case decided against us.
Okay, he was apprehended from which place?
From Gulagat, my lord.
Golaghat. Mr. Mr. Aralil and counsel for the petitioner. All the respondents are there. Next one. This. Filing this repetition in Article 226 of the Constitution of India, the petitioner is invoking the habeas corpus jurisdiction of this court. For producing the wife and son of the petitioner, namely, wife means your wife.
Lordship.
The wife and son of the petitioner, namely Fatima Begum, Fatema, Fatima Begum, wife of Zakir, Jakir, Zakir Hussain, and Habibat, Habibar, Habibat Hussain, son of Zakir Hussain, who, according to the petitioner, were taken into custody by the police personnel from Golaghat police station on 25/5/2025, and thereafter their whereabouts are not known. Next para, the learned counsel for the petitioner has submitted, petitioner has submitted that as per instructions received by him, there was no reference pending against, pending or decided against the wife and son of the petitioner. Where is the statement that you went to the police station? You know, information is given.
Lord, paragraph, my lord. 4 and 5, my lord.
4 and 5.
Three also, my lord. 3 onwards. 3, 4, 5.
Okay. Next para, the referring to the statement made in paragraph 4 and 5 of the writ petition, it is submitted that on that after the arrest of his wife and son, the petitioner went to the Golaghat police station to know about the whereabouts of their whereabouts, and they were informed that those detained persons were taken to Matia detention camp at Gwalpara. So accordingly, the petitioner had visited the Matia detention camp and did not receive any information about the detained persons, and therefore they visited the Kokrajhar Holding Center under 7th Assam Police Battalion, Sarai Khula, but no information could be gathered. Next paragraph. Under these circumstances, we request the learned standing counsel for the FT matters, as well as Mr. P. Sharma. Huh?
I have something that particular. So my learned friend.
No, you still get the information.
Yes, I
We are requesting from the court, we are the standing counsel for the FT matters, as well as Mr. H.K. Hazarika, learned government advocate, to contact the Superintendent of Police, Golaghat, to obtain information as to the whereabouts of Fatima Begum, son of Zakir Hussain, and Habibar Hussain, son of Zakir Hussain, stated to have been apprehended by the police personnel of Golaghat Police Station on 25/5/2025. Next paragraph. The learned standing counsel for the FT matters and the learned government advocate shall send a downloaded copy of this order to the said authority to obtain information. List on, make it tomorrow.
I may start the cooking.
I will serve one.
Oh, extra copies,
I will.
please. Okay. Just for that, you said that extra copies of the writ petition. As well as soft copy of the writ petition, we served on government advocate and the understanding counsel for the FT matters, so as to enable them to communicate with the Superintendent of Police, Border Golaghat.
My lordship, in this case,
Yes.
my lordship, in this case, it is the petitioner's wife who has filed this case. My lordship, petitioner husband was arrested on 24th May 2025, my lordship, at 3 AM at night time, my lordship. 24/5/2025, my lordship. I have already mentioned
Okay.
in paragraph 4.
Any opinion against him?
My lordship, he got bail from this honorable court and case is still pending, my lordship. And he has also,
Where is the opinion against him?
that is opinion, my lordship, that is at
40. Raghunath Patel, no?
that is at page 28, my Annexer C.
28.
Yes, my lordship.
And where is the order of the High Court granting you bail?
Page 36, Annexer E, my lordship. And also, and before getting from the order of the High Court, he was already released from the Supreme Court, my lordship. Annexer E, page 36, and is still pending before this honorable court. Yeah. And my lordship, at page
Just a moment. I mean, just check out WPC, status of WPC 1534 of 2019. WPC 1534 of 2019. Yeah.
Let me get the instruction, my lord, tomorrow by tomorrow, man. Then your lordship, if because
My
Yeah,
lordship,
hardly have any time. We say that if he's not already deported, he shall be released.
yes,
This is an order of the court. That bail order has to be respected.
yes. No, otherwise also, my lord, I can put us a compass.
sometimes they say Pokrajar,
That-
sometimes they say
That,
Gwalpara.
my lord,
I think
by
last-
tomorrow, your lordship may direct for release. Let
Hmm?
me get queries.
My lordship, I
about-
get the bail for-
Just,
Let me get the instruction, my lord, query about the person first, my lord. Then your lordship may direct for release.
no, but then tomorrow, you see, we have limited time tomorrow. We can't afford to spend time.
My lordship,
Tomorrow is a day we don't.
Yes, your lordship may pass a my lord, simple order that if he is not deported, he may be released. Then-
In the meantime, you get information.
Yes, sir.
We'll permit that also.
my lordship, I want to break to something, my lordship. Today morning, the petitioner's, my petitioner brother told me, he's not sure, but he told me that he is in Kokrajhar
Rajab, okay.
or in Gwalpara.
Okay, your name?
TK De, my lordship.
Mr. TK Dale, and counsel for the petitioner.
Or make-
All the respondents are there. Uh, Filing this writ petition on Article 226 of the Constitution of India, comma, the petitioner is seeking issuance of a writ of habeas corpus for producing Ainuddin, AINUDDIN, alias Mohammed ND. Mohammed Ainuddin Ali, AINUDDIN, ALI. MD means Mohammed, huh? Not capital M, not M full stop, D full stop. Mohammed Ainuddin Ali, comma, her husband who has been taken into custody on 24/5/2025 by the police personnel of Samaguri Police Station. Without issuance of any notice or arrest memo. Stop. Next, by the learned counsel, the petitioner has submitted that the opinion dated 14/9/2018. This is at page 28. Was passed against the husband of the petitioner by the learned member, Foreigners Tribunal, 2nd Nogao, page 28. In FT case number so and so, reference case number so and so, thereby declaring the petitioner to be the husband of the petitioner to be a foreigner of post 25/3/1971 stream. So it is submitted that the said opinion has been challenged by filing WPC 1534 of 2019, which is still pending for disposal before this court, and that by an order dated 3/12/2021, this court had granted bail to the husband of the petitioner on conditions as mentioned therein. Next, the learned counsel for the petitioner has also submitted that during the COVID period, pursuant to orders passed by the order dated
Next,
21/3. No.
10/9/2019, 10/5/2019. That is Guwahati High Court order 21/3/1.
You said Supreme Court also?
Yes, 10/5/2019, Annexure D, page 33.
Page 33.
Annexure D, page 33. Relevant portion at page 34.
No, please tell us this order, page 36 order was according to this, did you take bail or you took bail in terms of the Supreme Court order?
I was released as per the Supreme Court order before.
That means the bail which was granted by order dated 3/12/2021 was not complied with.
It was complied with. How far I know, because we were regularly before the.
No. These two things have different connotations. You see, the bail granted by this court is in connection with this opinion. And Supreme Court granted you bail is a general bail order during COVID period. That bail will not protect you from deportation because of the fact that the deportation was not stayed. So if this order of the bail was not taken and you did not inform the court, then you are in a difficult position.
If I have informed, if I have not been informed, they should have given an.
No, they will not inform you.
I have not.
When you have been declared as a declared foreign national, there is no requirement of any law to give you arrest memo to give compliance with section 48, 47. Those are not required.
How far we have given, my lordship, and even after around 28, I myself also given.
You see, please try to understand. We are asking you questions with some purpose. Because if this bail was not taken, then this bail order of 3/12/2021 lapses. This protection does not cover you. We'll take a short break. You, in the meantime, call up these people and ask him. It will be very vital. We'll take a short break and come back. Yes.
Item number 10, your lordship was supposed to grant interim protection, but your lordship may grant protection.
Come back in.
In this case, my lord, I have got the instruction, my lord. He has never submitted bail bond and he didn't inform the, my lord.
No, we understand. We understand that. So
only after arrest, my lord, they have the one of the advocate. They're saying that one of the advocate came. Then only they have submitted the order, my lord.
I understand.
So,
I don't know. We can't. we can't really advise, but you talk to your friends. I think you'll have to file a fresh IA for a fresh bail. But that bail order doesn't protect you from anything. Supreme Court order will not protect you. You think what to do, but we'll say not to deport.
Yes,
Okay. He's in Kokrajhar holding center.
that information I could not
You
get. I
cannot
just.
get. Okay. We'll just say that he'll produce the certified copy before the Superintendent of Police.
Yes.
Which place?
No comment.
Nagaon. And they will instruct that wherever he is being held will not be deported,
Yes, if not deported.
if
only.
not deported. Okay. Prior to the prior to obtaining of bail pursuant to order dated 3/12/2021, passed in WPC 1534 of 2019, the petitioner was already released on bail pursuant to order dated 10/5/2019, passed by the Supreme Court of India in WPC number 1045 of 2018. Give a dash. Supreme Court Legal Services Committee versus Union of India and another. Which was a bail granted owing to the prevailing COVID-19 pandemic situation. Next para. At this stage, the learned standing counsel for the FT matters has submitted that the said order dated 10/5/2019, passed by the Supreme Court of India, may not protect the petitioner, the husband of the petitioner from deportation, as the petitioner as the husband of the petitioner did not take bail pursuant to order dated 3/12/2021, passed in WPC 1534 of 2019. Next, be that as it may, taking note of the fact that the hearing before referred opinion dated 14/9/2018 is a subject matter of challenge in WPC 1534 of 2019. The court is inclined to provide that on a production of a certified copy of this order before the Superintendent of Police within Superintendent of Police Nagaon, the said authority shall take urgent steps to inform the holding center, wherever the petitioner is, the husband of the petitioner, namely Ainuddin alias Mohammed Ainuddin Ali, is presently being held, shall not deport him out of the country, if not already deported. Next, it will be submitted that the learned counsel for the petitioner has, just before this paragraph, the counsel petitioner has submitted that as per instructions received from the petitioner, the husband of the petitioner is currently lodged at the holding center, care of 7th AP Battalion, Saraikula in district of Kokrajhar. This, then you say the next paragraph being. Next paragraph. In the meanwhile, the learned government advocate shall also transmit a downloaded copy of this order to the respondent number 7 to bring the order to the notice of the said authority. Next paragraph. This is the matter on after reopening 18/7/2025. But Mr. Pang
Madam.
and Mr. Hazarika, before I commence the court proceedings tomorrow morning, kindly get us information.
Yes.
Be here before 10:30. We're not fixing it tomorrow because we have
Yes.
some
Yes.
logistic difficulty tomorrow.
Yes. This is after vacation.
We're fixing it after vacation, but
Yes.
just inform the court about
Yes, where about deposit?
whereabouts. So that at least he's not deported when the matter is pending before this court.
Yes, ma'am.
Yes, item 10.
10, my lord, your lordship was supposed
Okay.
to grant bail, my lord.
Okay. Heard. Mr. J. Ahmed, learned counsel for the petitioner. Also heard. All the respondents are there. Next one. By filing this writ petition and article. Page 30 is the opinion.
Yeah.
I think this writ petition and article 226, opinion dated. Page 30, opinion dated 13/5/2024. Passed by so and so in reference number so and so. They were declaring the petitioner to be a foreigner of post 25/1971 stream. Next, the learned counsel for the petitioner submitted that there was some inadvertent delay in setting the said opinion dated 13/5/2024, and by producing a photocopy of the certified copy of the order sheet in case number BPT 1982 of 2007, they submitted that the arguments was heard by the learned member, foreigners tribunal, Bangaigaon number 2nd, Abhyapuri, on 28/11/2017, and the next date for delivery of opinion was fixed on 21/4/2018, and since then the matter has been adjourned on several occasions by the learned tribunal for pronouncing the opinion. And after about 7 years, the opinion was delivered on 13/5/2024, of which the petitioner had no information, and therefore some delay. Next paragraph. You should notice returnable in 4 weeks, extra copies in course of the day. The prayer for call for the detainment records bail of rupees, 10 days time to take bail of rupees 5,000 to the satisfaction of
SP, border Bongaigaon.
SP Border Bongaigaon. You filed these documents by way of an affidavit.
Yes, sir. Hello, 10 days given. 10 days time given.
10 days time to take.
15 days, my
No, no, no.
lord. Vacation is there.
Their vacation. Police, very good.
No, no, here.
Your client also takes vacation with the lawyer. Very good.
Because of certificate we have got no problem, my lord.
Item 24.
May I please, Lordship?
Yes.
Lordship, the contested case, Lordship, the important.
You have amended the cause title.
Yes, Lordship.
Where is the opinion? Which page?
64, Lordship.
Pardon me?
64, Lordship. And it's
64.
64.
Okay.
Seventy to 85, not submitted the Buddha list.
Okay. 23 opinion you are challenging now. You have to wait for some time for bail.
Consider the bail, Lordship.
Heard Mr. N. Ahmed and counsel for the petitioner. All the respondents are there. Opinion, page 64, dated 10/8/2023, passed by so and so and so and so. They were declaring the petitioner to be a foreigner post 25/3/1971 stream. Notice extra copies in course of the day. Notice make it returnable on 30/7/2025. Extra copies in course of the day. Prayer for bail shall be considered on receipt of records. Next paragraph. In the meanwhile, if the petitioner, namely so and so, is apprehended, she shall not be deported out of the country without order of the court. List on 30/7/2025.
Twenty-five with 26.
Yes.
My lord, it's an ex parte order law. And the petitioner was arrested on 7/8/2024 law. Lordship, I think in item number 26, it's also a legal aid matter, Lordship. This is also a legal aid case. And I think there is no reference against in item number 26, Lordship. The reference is against only this petitioner, item 25, Lordship.
So, 1991.
Yes, madam.
Yes, Lordship.
Nineteen 91 opinion, madam.
Okay, since we are not taking up the hearing today, we will say that you will not be deported out of the country till the next date of listing. Your prayer for bail will not be considered now. She's, the petitions are held where?
In Matia detention.
Matia detention.
I think Lordship, in the second petition, Lordship, he is released on bail as per the Honorable Apex Court order, the 3 years thereafter he was released.
Meher.
Meher. Meher is the brother of this petitioner in item 25, Lordship.
Meher to 20 corona.
Yeah,
Yes, detained corona.
No, he was also arrested. Right now he is outside.
But he is not detained now.
Now he is not.
That is-
Meher was released. Meher would be.
Okay.
I think
We
in
separate
item
orders. In item 26.
26, no one represented today, Lordship.
Hmm?
To 26, no one is there today. I'm there in 25. I'm appointed
Oh,
as
okay.
legal aid counsel in
Oh,
25.
okay. Item 26 says that,
Both these
Uh,
matters are take together because my lord the record.
no, we understand, but we have to pass, item, since both are listed, we'll have to pass orders.
Yes,
26 is listed, so we'll
Yes.
have to pass orders there.
yes.
None appears on call for the petitioner. All the respondents are represented. As the record is requisition from the tribunal is received, the court proposes to hear the matter after vacation. List on, so, don't say after vacation, say list on so and so. We'll give the date. In this item 25, pass a separate order. But Mrs. D. Ghosh, non-counsel with the petitioner. Sorry, not legal aid counsel for the petitioner. The respondents are represented. Next paragraph. This matter is tagged along with WBC 7746 of 2019 as the relevant records of the tribunal is tagged with this said writ petition. Next paragraph. As the opinion assailed is of 31/7/1991, at this stage, the court is not inclined to consider the prayer for bail. Next paragraph, however, in view of the pendency of this writ petition, it is provided that the petitioner, namely Muhammad Zakir Ali alias Zakir Hussain, who is stated to have been apprehended on
7/8/2024.
7/8/2024,
8/24.
pursuant to the said ex parte opinion, shall not be deported out of the country, if not already deported. Next paragraph. Since you are a legal aid counsel, we are asking you, how will you communicate this order to the SP Borbata?
This through his son, Lordship, who has shown this affidavit,
Okay.
through his son.
The petitioner is, Zakir Ali is the son or the?
No, he is the petitioner
Okay.
against whom the impeachment order is
Okay,
passed.
but his son is
Son,
available. Son is
Mohit
available.
Rahman, who
Okay.
has shown this.
Okay.
affidavit.
Next paragraph. The legal aid counsel has submitted that as the petitioner is in detention, comma, the affidavit in support of this writ petition has been sworn by his son, namely Mohibur, Mohibur, Mohibur Rahman. So accordingly, we are inclined to provide that we are inclined to grant liberty to Mohibur Rahman, comma, son of the petitioner, to produce a certified copy of this order before the Superintendent of Police, Borpeta, to bring to the said notice of the said authority that the petitioner, comma, if not already reported, shall not be deported out of the country without order of the court. Next list on. Give a date for hearing. After duty.
After you.
This is 29th.
29 was.
29?
29th, I'll be out of station now.
Out of station. 31st,
Yes, Lordship.
31/7/2025.
Lordship, one submission, if any assistance of mine is required with regard to item 26, since that is also a legal aid case, then I can assist Lordship on that.
We are not saying anything. Right now, we are deferring it.
Yes,
Both
Lord.
the cases, we are deferring it together. So if necessary, we will pass orders.
Yes, Lordship.
Since the legal aid counsel is there, we don't know about the his present.
Yes, Lordship. Deeply well.
Yes, item 27.
Lord, was asked to pay instructions whether he was without
Yes.
appearing without. And
Yes.
instruction is there, Malad. From the instruction, it is seen, Malad, he's regularly appearing since 2025.
Pardon me, did not get it. Please repeat again.
Regularly appearing, Malad.
Okay.
Only issue is that, Malad, because as your lordship will passed an order in 3099, Malad, same case.
Yesterday, lordship passed
Yesterday,
on item
lordship.
5, Malad. That order has not been uploaded as yet. Passed on order.
Item WPC number 3099/2025. Same order maybe passed.
What did you say there? I don't remember.
My lord, there your lordship has directed us to file an affidavit to object the release of the bail because it was on the basis of Supreme Court's, my lord, common order. They were outside, my lord. The petitioner was outside. There is no specific bail order by this honorable court, my lord. My lord, here the petitioner is admittedly declared foreigner, my lord. He has preferred retake petition. With petition before version. So. He was declared foreigner, then he was released on the basis of Supreme Court's judgment, order, my lord, common order of releasing bail. So this order was passed on 15/7/2019. Yes. Today morning also your lordship has passed an order. That.
Yes, yes. Yesterday item number 5, madam. Yesterday it was item number 5. Yesterday similar order was passed in item number 5. Similar case.
Item number 5.
Item number 5.
Same. Husband, wife. Petitioner, son, madam.
No, petitioner is the wife.
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 Vegetable. Sorry,
Is
I think.
Who is Rizia Khatun?
Yes, ma'am. Wife.
Rizia.
Wife.
Delicious, yes.
What is the date of his release? On bail?
Date of release, my lord, is my lord, 15/11/2021, my lord.
What is the name of the detained person?
My lord, Majibur Rahman alias Majibur Sheikh, my lord. Majibur, Majibur. Majibur Rahman alias Majibur Sheikh.
Rahman or Rehwar?
Rahman, Rahman, my lord.
Alias?
Alias Majibur Sheikh, Sheikh. Majibur Sheikh, Majibur Sheikh.
Okay.
Well, obliged, lordship.
Yes, 28.
My lord, may I please, the lordship? My lord, on the last
You
occasion.
got the Wakalatnama?
My lord, we have the certified copy, my lord, we are getting it by today, my lord.
Which one?
In both the cases, my lordship has allowed us to execute the wakalatnama. So we are corresponding with the petitioners, my lord, we are getting it today. So, my lord.
No, it's been, you've been allowed to meet.
No, not yet, my lord, because with the certified copy of the order, we are required to go.
Okay.
That's why, my lord, we are getting the copy today, my lord. And
Okay.
another thing, my lordship make a query to me, my lord, that as I have not pleaded in my petition regarding, my lord, that after the bail order, my lord, whether I am complied with the
Yes.
my lord, conditions or not. That instruction, my lord, was asked from my learned friend, my lord, on the last occasion, my lord. My instruction, my lord, is that up to date, my lord, we have time to time appeared, my lord. But no document had been executed or furnished to me to show the proof of appearance, my lord.
Okay. Yes.
My lord, till my lord, the from 6/5, she is not appearing. 6/5, 13/5, 25. Last in the month of May, she didn't appear. The petitioner did, my lord, the appear. Picked up on 25th, my lord.
25th, my lord, so
25, 5.
five. Before that, I am
So-
appearing, my lord.
From my lord, only up to May, April, my lord.
He had appeared.
Yes.
Monthly once, my lord.
No.
No,
Every week.
fortnightly.
Every week, my lord.
Huh?
Every week.
Every week.
Yes. So 6th he was supposed to appear, 6th didn't appear.
Okay.
13th he didn't appear. 20 he didn't appear. Then 25th he was picked up.
Okay. Then we list it after the vacation. In the
Mark.
meantime, we grant you liberty that if you get it,
Yes,
the
my lord.
pendency of this shall not be a bar for you to file it without prejudice.
My lord, the wakalatnama, my lord.
Once you file it, you will have to challenge the
Opinion.
Opinion, yes.
So,
And
we are keeping it pending, but we are giving you liberty.
my lord. My lord, as we are also apprehending that, my lord, in the meantime, we may be deported also, my lord. That stay, if my lord may be pleased to observe and because, my lord, we have come to know that one case, my lord, today itself that a statement has been made that the
Because deportation has to be made.
my lord,
2016 opinion was there.
my lord. No, my lord, in the first case, we have already challenged that opinion before my this honorable court, my lord. That has also been dismissed, and thereafter, my lord,
That's why once that has attained finality,
my lord. Now,
once it has attained finality, then we have no other way.
my lord.
But that now it can't be stalled.
Yes.
My lord, the deportation, my lord, we are not saying that there should be a blanket ban on deportation, my lord. But once they are required to deport, my lord, at least the Bangladesh government is required to accept.
That we don't know.
My lord.
My jurisdiction ends at the border.
No, my lord.
What happens in Bangladesh?
Yes, my lord.
I think I can't touch.
My lord. My lord, may fixed it after the vacation. Will not.
I'm saying I am making a mistake. It should be we.
My lord.
We don't have jurisdiction beyond the borders.
My lord.
Mr. A.R. Buyal and counsel for the petitioner has submitted that the petitions were granted leave by this court to meet the detained person, namely Sohrab, S-O-H-R-A-B, Sohrab Ali Paramanik, P-A-R-A-M-A-N-I-K, alias Sohrab Ali Paramanik, P-O-R-A-M-A-N-I-K. Then the last order. Or the person, who is the husband of the petitioner. And obtain Wakalatnama. So it is submitted that as the petitioner was required to produce a certified copy of order dated 24/6/2025 before the concerned authorities, the said process is likely to be done today.
My lord.
Stop. In view of above. And taking note of the fact that the court will be on vacation from 28/6/2025 to 13/7/2025. Come on, that this matter will listed. 18/7/2025. Full stop. Next para, the counsel for the petition shall inform as to whether the order of 24/6/2025, whether the petitioner has got the visitation right in terms of order dated 24/6/2025.
My lord.
The last order, we made a mistake of writing a name. We referred Mr. Sikdar.
My
Understand?
are, yeah, common name is.
Mr. A.R. Bhuyan.
29.
29.
Similar, my lord, my friend can.
Yes, in this case, my lord, he appeared regularly. Only the same thing, my lord. Despite of this honorable's, my lord, court's order of dismissing the, my lord, the petition on 13/12/2018, they are sitting ideal.
Pardon me, please repeat
My lord,
again.
the opinion was challenged before this honorable court. This
That was
honorable.
dismissed.
Yes, that was dismissed.
13/12/2018.
Then there is no, my lord.
Okay.
29.
Same thing. Yesterday's matter, same order. Only the name of the petitioner and the detained person will change. Petitioner is Rashida Begum,
Saha Ali.
RASHIDA Rashida Khatun, and the
Khatun.
detained person, his name is
Saha Ali, my lord.
in the paragraph 2 of the last order,
Saha.
Mohammed Shaha Ali, SHAHA, Shaha Ali,
Alias Saha.
alias
SAHALI, Saha Ali.
SAHA
HALI. ALI.
ELI, Saha Ali. Acha, okay. SAHA, next is ELI or same word,
Same.
one word.
No, my lord, there is a space between Saha
Acha,
and Ali.
Saha, SAHA, Saha Ali. Okay. Same, this on 18/7/2025. We're passing the same order as in
Yeah.
item 3 or
Yes.
item 3, right?
Yesterday.
Yesterday, item 5.
Yesterday.
Okay, yes. My secretary remembers.
Mild. Obliged, my lord, highly obliged.
Item 30.
May I please, your lordship, please.
Correction.
Yeah, in this case, my lord, on last occasion, my lord, I was allowed to, my lord, correct the cost title so far as the page number 3 is concerned, my lord. And lordship was also pleased to, my lord, grant me bail to appear before the concerned, my lord, SP at Jorhat, my lord. But inadvertently, my lord, that has been reflected as SP border Morigaon, my lord. And
Oh,
the-
yes.
regarding the
Okay.
cost.
It should be
correction part,
Jorhat.
That has not been reflected, my lord.
Okay, we'll extend time then.
Yes, my lord.
Okay.
I filed the cost title before the AOJ, my lord, 50 section on the next day, my lord.
Pardon me?
My lord, I submitted the corrected cost title, my lord, amended cost title before the AOJ, my
No,
lord,
it's
the
okay.
very next day, my lord.
It's okay.
My lord. Probably it is in the file, man.
It's okay. Yesterday the court master, they
Yes, yes.
gave us this,
Yes.
the request, and therefore we are listing it. Mr. Z. Hamad, the counsel for the petitioner, has submitted that pursuant to order dated 23/6/2025, he has submitted the amended cost title and the amended cost title has been brought on record. Next paragraph, he has further submitted that that in paragraph 2 of the order dated 23/6/2025, it is mentioned that the opinion dated 26/12/2024 was passed by the learned member, Foreigners Tribunal, Jorhat, in case number JFT /32/2000/14. Stop. However, in paragraph 6 of the same order, the authority before whom the petitioner was required to take bail was referred to as Superintendent of Police within bracket border, close Morigaon, which should have been Superintendent of Police within bracket border, bracket closed, Jorhat.
Man.
Stop. Accordingly, the court is inclined to provide that the reference to Superintendent of Police within bracket border, bracket close Morigaon, appearing in paragraph 6 and 7 of the said order, 6, 7, and 8 of the said order, shall now be read as Superintendent of Police, border, Jorhat. Full stop. Next paragraph. Accordingly, the court is inclined to grant further 10 days time from the date of this order for the petitioner to take bail before the Superintendent of Police, border, Jorhat, on terms as indicated in the order dated 23/6/2025. Next paragraph. This order shall be read together with order dated 23/6/2025. Next paragraph. List the matter after 4 weeks as indicated in the order dated 23/6/2025.
Observation may kindly be made regarding the reflection of the name of the respondent number 4, 5, and 6 in the cause list. Otherwise, they're not.
Oh, they will come automatically. Will come.
No, my lord, I personally approached the IOJ, my lord. He said that if since there is no direction from this honorable court, my lord, they cannot do it automatically. My lord. Although I submitted application, my lord. An observation may kindly be made.
কি আছে এবাৰ ফোন কৰি খবৰ লৈ ল'ব লাষ্ট টাইমত দৰকাৰ হ'লে অলপ পাছ কৰিব লাগিব Acha, just say that, huh? I understand what has happened.
Might.
As the amended cost title has been submitted, the necessary amendment to these cost titles shall be incorporated in the petition as well as the central records. Then list after also. Okay.
I'm deeply obliged.
It's good that you are vigilant.
Deeply obliged.
One.
My lord, the impugn order, page number 38, my lord,
Page
page 38.
38.
Order dated 10/2/2025.
Okay. So E. Halil and counsel for the petitioner. The respondents of the opinion dated page 38. Opinion dated 10/2/2025. Passed by so and so in case number so and so, SP inquiry number so and so. Declaring the petitioner to be a foreigner of post 25/3/19 Sullivan Street. Notice return in 4 weeks, extra copies. Call for the records. The prayer for bail is opposed by the understanding also for the FT matters. 10 days time to take bail out of this 5,000 to the satisfaction of SP border.
Dorong Mungundu.
Pardon me?
Dorong.
Darang. Mangadai. Okay. This after 4 weeks.
Okay.
32.
Yes, Mr. Abbas.
Page 81 is the impugn order.
81.
81 loss. 8. Declared on loss of 18/5/2023.
17.
2023 loss.
Oh, 2023. Okay.
18/5/2023.
Okay. This is J. Abbas, Law and Counsel for the petitioner. Page, respondents are there. Page 81 is the opinion dated 18/5/2023, passed by so and so in case number FT so and so, R case number so and so. They were declaring the petitioner to be a foreigner of post 25/1971 stream. Notice extra copies in course of the day. With the relevant records be requisition from the General Tribunal. It's going to be prayer for bail shall be considered on receipt of tribunal's records. Give it a fixed date, 37. 307/20. In the meanwhile, if the petitioner, namely Safia, CHAFIYA Khatun. What is his name?
Actual name is her lordship Sabia Khatun. He projected as Sabia Khatun lordship. Documents also.
Oh, opinion it is Shafia.
Safia lordship. But she all along she projected as Sabia lordship.
I should just make a mention there. The Land Counsel for the petitioner submits that although in the opinion, the name of the petitioner is mentioned as Chafia, CHAFIYA Khatun, KHATOON, but her name is Sabia Khatun, SABIA, KHATUN. Next one. In the meantime, with the petitioner, namely so and so, who is referred to as Shafia Khatun in the opinion, impugn opinion. Come on, she shall not be deported out of the country without order of the court. Prayer for bail shall be considered on receipt of records. List on 37/2025.
Oblasting.
My lord, item 50, my lord, man is in custody.
We'll try to take up, but we have very less time today.
Lordship is also rising, my lord.
But
If possible, my lord, immediately after that, motion, my lord.
we'll try to take it up
My lord.
because after that, this is the lot
My lord.
for bails which I have to take up. It is
Yes, my lord.
staring at me. Sitting singly, so we can't help it. Yes.
Then 33.
Make please, your lordship.
Yes.
Lordship, the impugn ex parte order is starts from page
Page.
46, your lordship. Your lordship. Earlier the proceeding started, your lordship, and it was kept as filed up, your lordship. Thereafter, again, the proceeding started. And my humble submission, your lordship, my stand in this regard is that, your lordship, when the second time the proceeding got started, your lordship, I didn't receive the notice, your lordship. Your lordship, page 47, your lordship. From 2022, your lordship. 31/8/2022. I was shown as absent, your lordship. I was picked up, your lordship, and now I'm in Matia Detention Center, your lordship. Actually, your lordship, I am a resident of Hojai district, your lordship. We used to go to Karbi Anglong for agricultural activities.
Whatever happened, we'll have to call for the records.
Yes, your lord.
Had Mohammed I. Hussain and counsel for the petitioner. All the responses are there. Page 46. Opinion dated 8/11/20. Ex parte, this is ex parte.
Expert.
Ex parte opinion dated 8/11/2023. Passed by so and so. In case number so and so, police reference number so and so. By declaring the petitioner to be a foreigner post 25/1971 stream. Notice returnable on 37/2025. Extra copies in course of the day. Relevant records be requisition. Usual process as well as by email to the following email address of the Learned Tribunal. Next fella. Prayer for bail shall be considered on receipt of the records of the tribunal. Next fella. In the meanwhile, if the petitioner, namely so and so, is apprehended, shall not be deported out of the country without order of the court. He's been taken into custody.
Yes, your lordship.
Okay, then change it. The last paragraph, the Learned Counsel for the petitioner has submitted that that in the meanwhile, the petitioner, namely Moinul Haq, alias Mohammed Moinul Haq, has been apprehended on
Lordship, 20. On 25/6/2025.
25.
6/2025.
No, something is wrong.
Also, page 17.
I don't know. I'm reading your synopsis.
Lordship.
In the last page, you have written on the strength of the order, you met the
Yes, your lordship.
petitioner on 26/25. He cannot be apprehended on 25
No,
and
therefore, the family members of the petitioner visited the petitioner and met him. Also, your lordship, this is a typographical mistake. your lordship.
okay. So what is correct?
Lordship,
25.
He was picked up on 25/6/2025.
Okay.
your lordship.
Is apprehended on 25/6/2025. So therefore, in view of the pendency of this writ petition, the petitioner shall not be deported out of the country till further orders of the tribunal of the court. Next list on 37/2025.
Right.
Actually, you'll have to bring this order to the notice of the next one. This petitioner shall produce a certified copy of the order for the Superintendent of Police.
Your lordship, Karbi Anglong T4.
Karbi Anglong Diffu. So as to enable the said authority to communicate this order to the holding center. Okay.
Right.
34.
Yeah, please, your lordship. My lord, this is an ex parte order. Page number 31, my lord. My lord, Mercy may kindly see, my lord, second last line, my lord. They serve the notice by way of hanging in a conspicuous place. So, my lord, the petitioner.
That's okay. Today we don't have time.
My lord, may I pray, my lord, one chance may be given to appear again, my lord, because totally unaware, my lord, 74 years old lady, my lord.
We'll take the matter as a last item today. If you want to argue.
My lord,
Last item.
no, my lord, I am not. It will lordship, as you lordship, my lord. Notice.
You can't help. You can't help. Today we have to act mechanically.
Yes.
If
Lordship
we,
may should notice.
Mr. A. Ali, Learned Counsel for the petitioner. The respondents are there. The opinion at page 31, dated 10/3/2021, asked in so and so, in so and so. Or they were dictating the petition. This is an ex parte opinion. Ex parte opinion is declaring the petitioner to be a foreigner.
He casted vote in 1971, man. 74 years old lady, man. Ailing person.
Notice extra copies in 2 days, complete relevant records. This here also make it 37, 307. Copy the record. My usual process as well as by email address to the following email address of the tribunal. For the prayer for bail shall be considered on receipt of records. Next, in the meanwhile, if the petitioner, namely Isha Bewa, is alias so and so, as there are two alias, Isha Bewa alias so and so, is apprehended, she shall not be deported out of the country without order of the court. Okay, list on so and so.
My lord,
Not to be deported.
35.
Yes, which
Ex
page?
parte order, my lord, page 15. Notice could not be served because the village has been eroded away. It is also mentioned in the order.
So 22. We'll
I
give
know.
you that protection not to be deported right now.
My lord.
Mr. A.W. Aman, same order. A.W. Aman, Counsel for the petition, respondents are there. Ex parte opinion dated 23/5/2022. Passed in FT case number so and so, R case number so and so. We were declaring the petitioner to be a foreigner of post 25/390 Citizen stream. Next, by the Learned Counsel for the petitioner submitted that as per the process service report, the house, the residence of the petitioner could not be located as it was eroded due to river erosion. Next will be that as it may. Notice written on 37, extra copies in course of the day. Call for the records. Email and usual process and email. Therefore, bail shall be considered on receipt of records. In the meantime, the petitioner, namely so and so, is apprehended. He shall not be deported out of the country without order of the court.
Hello.
Thirty-six.
Page 39, my lord. In order.
A.W. Aman, Learned Counsel for the petitioner. Opinion at page 39, dated 26/9/2022, passed by so and so in case number so and so, IMDT case number so and so. Again, there is a police reference case number so and so. They were declaring the petitioner to be a foreigner of post 25/390 Citizen stream. Notice extra copies in course of the day. Notice written on 37. Call for the records by usual process and email. Therefore, bail shall be considered on receipt of records. Meanwhile, if the petitioner, namely Muhammad Saira Khatun, alias so and so, there are two alias. Australia page 3 is apprehended, she shall not be deported out of the country without order of the court.
Grateful.
37.
Yes, 37. Okay, none appears on call for the petitioner. Opinion is at page 51. Dated 34/2024. Passed by so and so in FT case number so and so. FT within bracket DCP case number so and so. Declaring the
37.
petitioner to be a foreigner post 25 to 1971 stream.
Sorry, my lord.
Notice extra copies within 2 days. And notice determined on 37/2025. Let the relevant records be requisitioned by regular process and usual and email. Next, the prayer for bail shall be considered on receipt of records. Next, in the meanwhile, if the petitioner, namely page 2, so and so and so and so are apprehended, comma, you shall not be deported out of the country without order of the court. You are there,
My lord.
Mr.
A. Rahman.
A. Rahman, counsel for the petitioner. $38.
Two-pin order is page 62 million. Ex parte order will be
Page number
page 62.
62.
And petitioner detained on 25/5/2025.
25/5. Mr. A. M. Ahmed, and counsel for the petitioner. Respondents are there. Opinion, ex parte opinion dated. Page 62. Ex parte opinion dated 9/5/2024. Passed. By so and so in case number. So police reference number so and so. They were declaring the petition to be a foreigner post 25 to 1971 stream. Notice returnable. No, just before that you say the learned counsel for the petitioner submitted that in the meanwhile, the petitioner has been taken into custody on
25/5/2025.
25/5/2025. Next below. Notice returnable on same day, 307. Extra copies in the course of the day. Copy the records, usual process and email. Prayer for bail shall be considered on receipt of records. In the meanwhile, as the due to the pendency of this petition, comment is provided that the petitioner, namely so and so, page 2, so and so, who has been apprehended pursuant to the said opinion dated 9/5/2024 shall not be deported out of the country without order of the court. Next paragraph. The petitioner shall produce a certificate. The family members of the petitioner shall produce a certificate copy of this order. before the Superintendent of Police within the border, Morigaon.
Yes.
Bring the order to the notice of the said authority. Certified copy you'll have to produce. Certified copy you will have to produce. Is, you'll see, this one so and so, along with the connected IA 2101 of 2025. Yeah, this paid for bail in IA 2121 or 25 should be considered on receipt of records. It will IA to adequate better.
39.
May it pleases your lordships. My lord, it's an ex parte order dated 12/9/2017, lordship, page 28.
28.
Here, petitioner has received the notice, lordship.
Okay. Good.
An explanation is there in paragraph 5, lordship.
Okay, since it's a 17 order, we will question the maintainability, but you make your submissions on that day.
Yes, lordship.
Heard,
I have explained the delay because he
no,
was
whatever
not
it be,
aware.
but today we
Yeah.
don't have, really don't have time. Heard Mrs. D. Ghosh, and counsel for the petitioner, all the respondents are there. Page 28, opinion dated 12/7/2017. Passed by so-and-so in FT case number so-and-so corresponding to police reference case number so-and-so. They were declaring the petition to be a foreigner of post 25 in 1971 stream. This is ex parte.
Yes, lordship.
Okay, ex parte, opinion intentions. Next, brother.
I have annexed the order sheets also, lordship.
No, it's okay.
Processor.
Notice returnable on 37/2025. Extra copies in course of the day. Just before that, issues or notice, issue notice. Before that, you say keeping the issue of maintainability open, issue notice returnable on 37/2025. Extra copies in course of the day. Next slide, please. Let the relevant records be requisitioned through usual process and email. Prepared for bail shall be considered on receipt of records. In the meanwhile, if the petitioner, namely so-and-so, who has been apprehended on
On 26/5/2025.
26/5/2025, if not already deported, shall not be deported out of the country without order of the court. Next paragraph. The petitioner shall bring this order to the notice, shall produce a certified copy of the order before the Deputy Commissioner of Police, Border, Kamrup, Metro, Guwahati. To bring the notice or the order to the notice of the said authority. This from 37.
Deeply.
Item 40.
May it please the lordship. My lord, here the informed opinion at page 73, annexure 21. 73. No. So
Just a moment.
the opinion dated.
Just a moment. Which page?
My lord, 73, madam.
73. Okay. Mr. A.R. Sikdar, Land Counsel for the petitioner. All the respondents are there. Opinion dated, page 73, opinion dated 29/6/2024. Passed by so-and-so in FT case number so-and-so, corresponding to D case number so-and-so. They were declaring the petition to be a foreigner post 25 in 1971 street. Notice returnable in 4 weeks. Extra copies in course of the day. Let the relevant records be requisitioned from the concerned tribunal. Next paragraph. Prayer for bail is opposed by the learned standing counsel for the FT matters. Considering the projection made in this petition, 10 days time to take bail or rupees 5,000 to the satisfaction of.
No.
SP border no. List of the weeks of the city records.
Leave them.
41.
Mr. Sharma, can you request the authorities? This every tribunal gives a different style of writing the case numbers. If it can be made uniform,
Yes.
it becomes easy for our stenographers to record it, because otherwise
Yes.
what happens is that every time to concentrate on what is the case number, they take a lot of time.
Yes, Lordship. I will inform you.
If it can be done in a what you call uniform manner,
Yes, Lordship.
because everybody writes it differently.
Yes.
We really have difficult time to my stenographers to type it,
Yes.
then for us to correct it.
Lordship.
Yes, Mrs. Ghosh.
Your lordship, it's an ex parte order, lordship. Initially, he appeared, lordship, but it's not reflected in the order. I have annexed the order.
It's okay. Where is that opinion?
Opinion is at page 29, lordship.
29.
Yes, lordship.
We passed the same orders earlier.
And lordship, paragraph,
Last item was item number, yours,
item number, lordship, 39.
39, same as that.
Lordship,
Keeping the issue of maintainability open, huh?
lordship,
So-
may I submit one? Lordship, page 30, paragraph.
On the
2,
next
lordship.
date,
Lord-
on the next date.
Lordship,
Yeah.
he, subsequently, he was not issued any notice. Entire order
Wha-
sheet I have.
Whatever be
Because
the very
that
good
on
ground.
a particular day when he appeared,
Today,
there was no order, lordship, of the tribunal. No,
today,
the learned tribunal
uh,
did not pass any order. He appeared.
maybe,
No order, lordship.
maybe,
And it was in the year 2015. 2015 till 2018.
today we are not hearing anything.
The sheet is silent, lordship.
Today we are not hearing anything.
Lordship, he may be released on bail, lordship.
No. We consider it not to be deported right now. Heard Mrs. D. Ghosh and counsel for the petitioner. Because once we open the file, then it half an hour goes.
I can
So
understand.
all of this will be affected by you. So that's why today is not a good day to take up.
Otherwise, this is a good case, lordship.
Maybe we're not saying anything.
Yes, lordship.
No comment right now unless I go through the records.
Yes, lordship.
Mrs. D. Ghosh, counsel for the petitioner. All the respondents are there. Opinion dated. This is ex parte opinion
Yes, lordship.
Ex parte
Opinion
opinion?
dated 26/10,
dated
2018.
26/10/2018. Passed by so and so in case number so and so arising out of FT number so and so. They were declaring the petitioner to be a foreigner of post 25/3/1971. Same, keeping the issue of maintainability open. Notice extra copies in course of the day, call for the records, email and usual process. So prayer for bail shall be considered on the set of records. Next, in the meanwhile, if the petitioner, namely
Sukur Ali.
Sukur Ali, no alias.
No, no alias.
Okay, Sukur Ali, if not only shall not be deported out, if not deported, comma shall not be deported out of the country without order of the court. You have not been apprehended.
Yes, he's in detention, lordship.
Okay, detention.
He's about his whereabouts.
When?
I had filed earlier a petition.
Okay,
Yes.
when he was apprehended,
He was apprehended on 26/5,
Okay.
2025.
petitioner was apprehended on 26/5/2025, comma, if not deported, shall not be deported out of the country without order of the court. Next para, the petitioner shall produce a certified copy of this order before the superintendent of police border. It will be
DC.
deputy commissioner.
Yes,
Okay, deputy commissioner of police, Kamru Metro Guwahati, to bring the order to the notice of the said authority. List on 37/2025.
lordship, can it be on 17th, lordship?
70 is just not possible. We're fixing many cases on that day. There are special benches also. You can merely expedite. Maybe 25th we can take it up,
25th, yes, lordship.
maybe 25th then. 25/7.
42.
Right, please, your lordship. Your order is page number 27, your lordship.
Page
27, your lordship.
27. Mr. A.W. Aman, sorry, your name?
Muhammad A. Rahman.
Muhammad A. Rahman, learned counsel for the petitioner. All the respondents are there. Opinion is at page 27. Dated
8/7/2022, Your Lordship.
8/7/2022. This is in page 28. Details are in page 27. Passed by so-and-so in FT case number so-and-so. There are two references, huh? FT case number so-and-so, again, reference FT case number so-and-so. And where is the petitioner was declared to be a foreigner post 25 in 1971 stream. Notice returnability on 37/2021 to 25. Extra copies in course of the day. Requisition of records for usual process and email address. That's why the prayer for bail shall be considered on receipt of records. That's why in the meanwhile, if the petitioner, namely Fatima Khatun, is apprehended, she shall not be deported out of the country without order of the court. Next, the petitioner shall produce a certified copy of this order before the Superintendent of Police Border.
Dorong, Your Lordship. Dorong.
Darang Magade, to bring the order to the notice of the said authority. Okay. List on 37/2025.
Highly obliged.
43.
IMP order is page 82, Mother.
Page number
82.
82.
In detention, doctor.
He's in detention.
In detention. Okay. And Mr. A.M. Ahmed, and counsel for the petitioner. Respondents are there. Opinion at page 82, 23/2/2024. Passed by so-and-so in FT case number so-and-so. The reference case is in para 1, huh? IMDT case number so-and-so. Thereby holding the petitioner to be a foreigner post 25 in 1971 stream. Notice extra copy is within the course of the day. Notice is 37/2021. Extra copies in the course of the day. Prayer for call for the relevant records by usual process and email. Prayer for bail shall be considered on receipt of records. Next paragraph. The learned counsel for the petitioner has submitted that in the meanwhile, the petitioner, namely Tabar Ali, has been apprehended on
28/5.
28/5/2025. Stop. Only in view of the pendency of this writ petition, the petitioner Tabar Ali shall not be deported out of the country without order of the court. Next paragraph. The petitioner shall bring the order to the certified copy of the order. Should submit a certificate copy of it before the Superintendent of Police Border, Borpeta, to bring the order to the notice of the said authority. List on 37/2025.
If not already deposed.
Acha. If not already deported, shall not be deported out of the country without order of the court. Okay.
44.
Lordship would find an order on page 94, Your Lordship. The order was passed on 11/7/24, Your Lordship. But she was under the impression, Your Lordship, that the order was reserved, Your Lordship. After she came to know, Your Lordship, she applied for the order on 28/5 and she received it on 3rd of June, Your Lordship.
Where is the order sheet?
Your Lordship, page 94.
No, the order where it was kept reserved. How
No,
can you?
No, Your Lordship. She was informed by her counsel that it was kept in reserve, Your Lordship. So thereafter, Your Lordship, when she came to know, Your Lordship, she applied for this, Your Lordship. And the petitioner belongs from Bihar, Your Lordship. She was born and brought up in Bihar, Your Lordship. She was educated in Bihar, Your Lordship. And her
No,
documents.
if the order is reserved on some day, you'll have an order sheet.
Yes, Your Lordship. She was told, Your Lordship, that is my instruction. Your Lordship.
11/7/2024 order.
11/7/24. Still on time.
Yes, sir.
You've done very well. Okay. Mohammed I. Hussain, and counsel for the petitioner. All the respondents are there. Page 94,
Lords.
opinion dated 11/7/2024. Passed by so-and-so in case number so-and-so. In reference case number so-and-so. They are declaring the petitioner to be a foreigner post 25/3/1971 stream. Notice returnable in 4 weeks. Extra copies in course of the day. The relevant records be requisitioned by the learned tribunal, or from the learned tribunal. Next, by the prayer for bail is opposed by the learned standing counsel for the FT matters. Mr. However, comma. Considering the projection made in the writ petition, 10 days time to take bail out of this 5,000 to the satisfaction of Supreme Police Border, Sonitpur, Tejpur. Let's start the police and visit.
Lordship, with regard to item number 33, Your Lordship, I was under the impression that we are in the 7th month of July, Your Lordship. But Your Lordship, she was picked up on 23/5, Your Lordship. And I have mentioned it in the synopsis as well as in the body of the writ
Okay,
petition.
please write it down because this,
Your Lordship.
my secretary is
Lordship.
changed. Give corrected date to the court master, he'll communicate.
45.
And your item number also. Give the item number also.
Very pleasure. Lord, the impugn order in Lordship will find that page number 52. This is a recent order, not passed in the last month, 21/5/2025.
Page number?
Page number 52, 52.
52.
The order was passed from 21/5/2020. He's an expert in that. The petitioner did not receive the notice, therefore he could not enter again.
Mr. A. Ali.
A. Ali.
Land counsel for the petitioner. The respondents are there. Page 52, ex parte opinion dated 21/5/2025. Passed by so-and-so. In FT case number so-and-so, corresponding to R case number so-and-so. They were declaring the petition to be a foreigner post 25/1971 stream.
He's outside.
Notice returnable in 4 weeks. Extra copies in course of the day. The relevant records be requisitioned from the concerned tribunal. Next. In view of the although the learned, the prayer for bail is opposed by the learned standing counsel for the FT matters. Considering the projection made in the writ petition. 10 days time to take bail out of this 5,000 to the satisfaction of
SP border, Borpeta.
Supreme Police Border, Borpeta. List after force and visit for reports.
Lord, may I submit one thing, because some some of the certified copies of the voter list I obtained only today, may I submit it by way of additional affidavit? Before the
File an affidavit, you don't need leave for the court.
I am obliged.
46.
Mr. Lordship. Lordship, in this case, ex parte order was passed without giving any notification opportunity. My lord.
Which page?
Page 44. Page 45, my lord, get it from page 45. No notice was, sir.
Page 42. Okay. But Mr. M.R. Khondokar, Land Counsel for the petitioner. All the respondents are represented. Page 44, opinion dated. This is ex parte.
Ex parte.
Okay, ex parte opinion dated 34/2022. Passed by so-and-so in. Okay, this is, you have to see it, huh? There are two numbers. This corresponding to this. And this corresponding to this, like that. Huh? I'll say 1, 2, 3, 4. Past in so-and-so, corresponding to so-and-so, case number so-and-so, corresponding to so-and-so, by which the petitioner was declared to be a foreigner post 25/1971 stream. Next, the learned counsel for the petitioner has referred to the said ex parte opinion, and it is submitted that the notice of the proceedings was not properly served to the petitioner in accordance with law. Next one. Notice written over on 37/2025. Extra copies in course of the day. The relevant records we requisition from the concerned tribunal by usual process and email at the following email address of the tribunal. Next slide. You have not been apprehended.
Not able.
Okay, the prayer for bail shall be considered on receipt of records of the tribunal. Next, in the meantime, if the petitioner, namely Nurima Khatun, is apprehended, she shall not be deported out of the country without order of the court. List on 37/2025. Not to be deported.
I am the.
But Mr. Sharma, I think this order would be wrong. Notice is not properly served. Today we don't have time.
On presume that notice is served.
No, it's okay. Just look into it. On the next date, you may have to answer this. Yes, item 21. This will get the information.
Yes, my lord, he is Kukuraja detention, Kukuraja holding.
Okay, but Mr. D.K. Agarwal and counsel for the petitioner. Mr. MR Adhikari and CGC, as well as heard Mr. D.K. Agarwal, counsel for the petitioner, also heard Mr. MR Adhikari and CGC appearing for the Union of India. Mr. H.K. Hazarika and the government advocate appearing for the respondent numbers. For the respondent numbers 2 to 6. Next para. Pursuant to order dated 25/6/2025, Mr. J. Pang, that is standing counsel for the FT matters, has submitted that as per instructions received by him, the petitioner, the mother of the petitioner, namely Zarina Bibi, alias Zarina Khatun, against whom an opinion dated 4/7/2012 was passed by the learned member, Foreigners Tribunal number 1, Dhubri. In case number, you take it from last order, page paragraph 2. Last order, para 2. Since it was passed, was apprehended and is presently lodged at holding center.
Yes, Kukuraja.
Under 7th AP Battalion, Saraikula, Kokrajhar. Next paragraph. According to the petitioner, namely Abdul Mazid Ali, is permitted to visit the detained person at the holding center under 7th AP Battalion, Saraikula, Kokrajhar. By producing a certified copy of this order before the in charge of this holding center. And upon, thereupon, if the detained person, namely Jarina Bibi alias Jarina Khatun, if not already deported, shall be allowed to meet the petitioner and one family member and to obtain her wakalatama on the wakal, what to be authenticated by the in charge of the holding center. Next para. Is the journalist standing also for the FT matters has raised preliminary objection as to maintainability, comma. Let the said objection be brought on record by way of an affidavit to be filed prior to the next date of listing. Next para. List on 21/7/2025. You filed that affidavit here also. Of maintainability when you are raising your file.
Yes, yes.
We are permitting you to visit
Two other family members.
one family members. There are reports of some disturbance there. That's why.
My state deportation, if my deportation may be state.
Pardon me?
My mother's deportation may be state.
We have already said that. Not to be deported. No, we are not staying the deportation. No, man. No, deportation was not stayed.
No, madam.
Till next hearing, when vacations are
No.
starting. So Honorable Supreme Court is also on vacation.
No, we don't know, but we are not staying
They
it.
can deport me anytime. I'm in at their hands, at their mercy.
No, but we are not saying anything.
Much obvious.
Upgraded item 17.
17. May I please, your lordship?
Yes.
This matter, your lordship heard, my lord, on the last occasion. And here, my lord, opinion was, my lord, passed on the basis, my lord, the electronic voter list was not considered. Page 63, my lord. So initially, my lord, there is interim order, but he did not appear.
No, the last order we noticed
And
4/6/2025, we examined some documents and we found discrepancy.
And we have filed affidavit, my lord. Your lordship, my lord, granted liberty to clarify the discrepancy
Where
of
you
them.
have filed that affidavit?
We have filed one on 30th of May, my lord.
30 May, it's not
Lord.
there. You have filed in the IA or in the main case?
In main case, my lord.
The main case. Huh?
11/6, my lord. 11/6. Additional affidavit we have filed. my lord.
वही तो कोर्ट लगा दिए कोर्ट कहाँ लगा तो पिछड़ दी पड़ेगी ना एफिडेविट तो होता है इसे डेट पिटीशन ना हो तो
Yeah.
Why do you want this matter to be taken up out of turn?
My lord, he was on bail, my lord. This amount court granted bail, my lord, by order dated 39/2022. We
Okay.
have filed an IA, my lord, for extension of the, and the last occasion, my lord, as the point involved, my lord, is legal issue, my lord. Whether the electronic copy is admissible
You
or
did
not,
not take bail in 2022.
lordship. And he, my lord, after filing, my lord, he left, he was out of station, my lord. He left.
That we can't encourage.
Lord.
Once the order of the bail,
So your lordship, my lord, observe that main case will be.
we'll take up the main case. We
Lord.
can't grant you extension. But
And-
today we don't have time to hear.
And issue, my lord, is otherwise covered case, my lord.
We don't have time to hear that today. Is there a special bench on 24th of September, July? Oh. 29th? Okay. How's this order in the, this is item number 17.
The issue has
When
been
is the order
settled in
will be in the
Mamta
DA?
case.
So, also as a representative, to a positive time, the matter cannot be heard today. Accordingly, release the matter for, release this matter on 20. When did I say 20? 29. 29/7/2025.
Lord, Article 48 of a student after 2 years detention, again she has been arrested with 9 months baby. So yesterday I mentioned.
40?
this matter.
48.
48, yes.
Okay, let us see that. 48.
But Honorable Supreme Court has said declared foreigner. So this is the order of the Honorable Supreme Court. It is, order is very much clear. The declared foreigner. Last para 7, last para, can you see?
What has happened to that ex parte opinion of?
That is, my lord, you have lost in every corner. But thing is this, as she was already in detention for more than 2 years, and thereafter, in view of Honorable Supreme Court's order, she has been released. So again, she cannot be arrested. And the order of the Supreme Court is declared foreigner. I am a declared foreigner.
My lord, your lordship has passed an order in item number 5, yesterday's case, my lord, 3099/22. Same will cover, my lord, because it is admittedly they have been declared foreigner, my lord. There is no case pending individual.
Do you file an objection?
Yes, my lord. We'll file an objection on that.
Okay.
My objection with the Supreme Court's order can be bypassed.
Yes, you want an order right now, I can give it. You want an order right now?
No, I want it to be released.
No, it can't be released. Once he is a declared foreigner, he does not have an inherent right to remain here. We are not passing any orders because of this vacation. In the meanwhile, many people will be affected. Therefore, we have
What
only
the-
requested him.
The agreement between 2 countries.
That we don't know. That is for the external Ministry of External Affairs to deal with it. We are just not passing the order because in the interim, when I pass one order, I'll be bound by that and we'll be passing similar orders. And in the meanwhile, many people will be affected. in this 15, to save this situation, for these 15 days, we are not passing any order. We are adjourning it. We are conscious of what order can be passed, but we are refraining from doing so just because in 15 days, we will not be able to hear anyone. So the rights of many people will be affected. So we know our limitations and we know the order which can be passed, but we are refraining ourselves in the last week, and till today we are refraining ourselves not to pass any comment. I'm repeating it for the third time. We are not passing any comments, as many people will be affected by that. And in the meanwhile, we will be bound by that order, and many hundreds of more people will be affected by that. So we are just refraining from doing so.
The Supreme Court has also given certain restrictions.
Okay,
in
that just
the-
for you to urge, but if you want an order, I am ready to pass it.
I want a good order, not.
No, we don't know. You see, every order passed is good order. How it affects material affects a party is a separate thing. Order is always good. We'll type in a fresh white paper.
Good for me.
Very Tahoma 14 point. One of the best points which has been searched by our experts. Everything will be spick and span. Okay, we're just adjourning it. Order similar to item 5 yesterday.
Yes. Yes.
That order, today also we passed similar order.
today also.
In item
Numbers-
number? Because Mr. Mahmood,
My lord.
you see, it may be,
Locally item.
you may disagree with it, but please tell us. You forgot about this case. There's a person who is apprehended for murder, life sentence. Now for COVID pandemic, this court says that you release him for the time being, for COVID pandemic. Will you say that on bail being granted, this sentence is over?
No.
Then, if he is a declared foreigner,
27 answer.
how can you keep him in the country without deportation?
No.
So that's an answer we don't have.
Supreme Court's order is.
Does it say this bail is forever? Every bail is, can be viewed by the authorities. The problem is that we don't want to touch it right now, so
Lord,
that
There is a Geneva Convention. India is a signatory of Geneva Convention. So that, so
we
many things.
have 1 minute. You can finish your argument in 1 minute and then we'll pass orders.
It can be argued in a previous time, but there are
Okay,
so many
the
things.
same order, item 5.
Today's
Just
item
just show it to
27.
me.
Today's item 27.
Today's item 27.
Yes, 27,
Similar order.
29.
Just find out who has taken it. I'll do the corrections. Huh? Okay. Other matters, if not urgent, will be adjourned. Yes, you wanted to say something?
The production list about the whereabouts of the petitioner and mother lordship.
Okay. For whereabouts, we make the same thing.
Yes.
Uh,
Tomorrow, if possible, my lord, because
if possible, tomorrow. Okay. This is this the production list item. Your item number is 1.
One lordship.
Item is for whereabouts. Huh?
Yes, lordship.
Similar orders we passed.
Item is 50 million.
You just say, and this is tomorrow. Requesting the Mr. J. Pang, that is standing also with the FT matters, to inquire about the whereabouts of so and so who has been apprehended on so and so based on opinion dated. Please give this opinion date and all. Just
Yeah,
write
yeah.
it and give it to the court person. See.
My lord, my item 50 million. Maybe
Item?
taken up tomorrow, my lord.
Item
50 million.
1550.
50 million.
It is for
My lord, I will file an IA for releasing the person in custody, my lord. There is an order of the Supreme Court to relieve him on bail. He was attending the police, but he has been taken into custody. Lordship has passed earlier not to deport him, but we
okay.
pay
50 tomorrow.
production list, there are 4 items.
Okay. Production list.
There are 4 more items, my lord.
4 more items for same whereabouts.
Yes, my lord, yes. 2 and 3 is whereabouts.
2 and 3 also same, whereabouts. Just give the case number, the date of order and detention, date of detention. Opinion, date and the
There
superintendent.
is no opinion, my lord, item number 3, my lord. Neither he is a declared foreigner nor is a DAD voter. Item 3.
Item 3, just write that and give it to the court
Yes,
master.
I'm giving you. And I mean, item number 2, my lord, a tribunal passed against me sorryful, my lord. I am not sorryful, my lord. I am the Sofikul Islam. And that is the case. Ex parte order. Notice was not served. Item 2.
2, 3, I'll get in commission.
Ah, yes, yes, yes. Yes, yes.
2 and 3 and this item 4, Mr. Suleiman,
Lordship.
Contested matter.
Contested declared.
pardon me,
Contested matter.
it's a contest, date of opinion,
Just opinion, Lordship, page 77, Lordship.
give the date.
Date to qua.
Date, Lordship, 6/5/24. 6/5/24.
6/5/24, okay.
24.
Okay, here giving bail. Notice extra copies in course of the day. Bail for bail is opposed by the understanding counsel for the FT matters, considering the objection. Bail of rupees 5,000 to the satisfaction of.
Superintendent Morigaon.
Superintendent of Police, Borigaon. Okay.
Item
Item 5,
Item number 5, Lordship, dated 25/04/25.
25,
04/25.
4/25.
Yes.
Okay, here also give bill same order. Your name, Mr.
Golaghat district.
Your name?
S. Ahmed.
S. Ahmed. Superintendent of Police Border,
Golaghat.
Golaghat. Okay. This 2 and 3 and Mrs. Ghosh,
Yes.
just give it very clearly so that there is no difficulty with the court master to understand.
My lord, I would like to withdraw this petition, my lord, with liberty.
Item
Seven.
7. Upon instructions, Mr. S. Ahmed, Land Counsel for the S.A. Ahmed, Land Counsel for the petition, 6 leave of the court to withdraw the this bill application and to approach the court again. Prayer is allowed. The matter stands dismissed on withdraw with liberty is paid. Yes.
Obliging.
May I please the Lordship? Lordship, I beg to mention item number 5.
Please speak loudly.
I beg to mention item number 5.
5.
Matter may be taken after vacation.
You want an adjournment?
Yes.
Okay, but it goes after vacation then. The prayer made by Miss
Miss R. Kha.
R. Kha, K-H-A. Then cause the petitioner, the matter stands adjourned today. List immediately after the ensuing summer vacation.
Obliged, my lord. May I please your Lordship? Lordship, I take the concern with other side. I beg to mention item number 10, Lordship. Matter may be passed over for the day, Lordship.
It goes after vacation.
Yes, Lordship.
It was on the prayer made by Miss
Sud.
S. Sud.
Yeah.
Land Counsel appearing on behalf of Ms. T. Som, Land Counsel for the petitioner. Place for adjournment. Prayer is allowed. List after ensuing summer vacation. Just record the presence, Mr. Kiboshul and AVP is present, even in item 5 and 7. Okay.
Obliged, Lordship.
May I please your Lordship? I beg to mention item number 21, Lordship. And let the matter be adjourned for the day, Lordship.
21.
21.
Okay, but it goes after vacation. On the prayer made by Mr. V. A. Chaudhary, Land Counsel for the petitioner. Matter stands adjourned today. List immediately after the ensuing summer vacation. This M. Kumari, standing counsel for the
CPL.
respondent is present.
Much up. Deeply obliged.
Yes.
Item 1.
Yeah, please, your lordship. This is in connection with FIR Jogi Kopa, PS case number 71 of the 2025.
Where is the FIR?
Yes, ma'am. Yes, it's on page 11, your lordship. I was arrested on 11/6/2024, your lordship. If you kindly allow me, your lordship, I humbly deny the charges as false and untrue. And I pray.
You are you correctly addressing the court on charge? Yeah, are you addressing the right court for a charge? Are we hearing a charge, explanation of charge right now? No. You're only seeking bail.
Yes, yes, yes.
Don't refer to charge right now.
Yes, sir.
Some other day we would have been very glad to hear on argument on charges.
Yes, yes.
But not today.
Yes, yes, yes.
We'll have to call for the case diary.
Yes, your lordship.
It's assault by stabbing.
My lord.
Okay, let
Your
the
lordship, if kindly just short date.
short date is after vacation.
Much.
There's no short date before that. Let the case diary from Jogi Gopa.
My
Let
lord.
the case diary be produced on when? It's from Jogi Gopa.
My lord. My lord, after, immediately after vacation.
Tell us the date.
My lord. 16, 17. My lord, 17, my lord.
Okay, 17/7/2025.
Much obliged.
Item 2.
To
Please, your lordship, 482 bail application. Lord, FIR is in page 10. May I read? The allegation, my lord, house trespass and assault. FIR is page 10, annexure 1.
you read that. We'll have to call for the case diary here.
It's a totally false and concord case.
Maybe.
My lord, incident was took plus 23/5/2025, but FIR was lost after 2 days, my lord. This is totally after shots, my lord.
We don't know.
Actual incident, my lord, I have stated in my
Still
petition.
not without case diary.
Well, kindly see, my lord, I have stated by.
No, I'm not for a moment saying that what you are telling is false.
My
But
lord.
cases like this, I would like to see the court case diary. Let the case diary be produced on. This from which place?
My lord, this son of my lord.
Sutia PS.
Sutia PS.
When?
16, my lord.
16/7/2025.
My lord.
Obliged.
Item 3.
May I please, lordship?
Yes.
482
FIR.
applications.
Where is the FIR?
FIR page note 12, your lordship, type copy.
211. Call for the case diary.
I am here only the driver of the vehicle. The allegation that I have made this coupon here and then sold some coupons.
That we don't know, but we'll have to call for the case diary.
At this point, I may be protested, so that I may appear before the IO.
No.
And
It's a society.
your lordship.
No.
Yeah, I am the driver of that of the society.
And the
Hey, we are not, for a moment, I'm not saying you are false or you are a criminal.
till
We'll have to
the
complete
arrival
this,
of the CDM, I may be protected, and so I will appear before the IO.
No. Let the case diary be produced on K3 PS.
My lord, Captain PS,
When?
my lord. 15, my lord.
15/7/25.
Right.
Item 4.
Item 4.
May I please, Lord? My lord, this is for clear bill application, my lord. FIR is at page
Correct.
number 9, my lord. Allegation is under section 118(1) of BNS. My lord, may I read the FIR, my lord? My lord, so far the affair no such injury sustained by the my lord informant. Kindly call for the city. By this time, I may be protected, my lord. I will appear before the investigation agency, my lord.
Then protect him. This only tried to attack.
My
lord, tried to.
Okay. Mr.
A Paramanik.
A Paramanik and counsel for the petitioner. As well as Mr. A Boshul and a DP for the state. Page 1. Apprehending arrest in connection with dispute PS case number so and so. Just wait, this is a case which was reported in newspapers also.
My lord, my lord.
No, then there was an incident.
My
My lord, here, my
I am
lord.
the car owner, my lord. I was inside the car.
My lord, here only, my lord, the
Then there
thing
was
is the
an
knife
incident.
is used, my lord. Knife part
Yes,
is
yes.
there, my lord. So, my lord, let
No,
the city maybe come, my
lord,
lord,
some
thought
of my
that, my lord.
Did not give you protection.
My lord, some of my friends went to
Immediately
purchase
after
my
vacation,
lord
my lord.
fruits. I
No,
am the
not
car
in
owner,
this
my lord.
case.
As well as I am the I am the YouTuber, my lord.
No, whatever has happened,
My
but
lord, no,
this is
since as
some
we-
incident had happened.
Yes, yes, my
Immediately
lord.
after
This
vacation,
is
my lord.
widely
My
reported
lord,
in
he has not
newspapers.
sustained injury. That's why
We don't know.
118 to my lord.
But if we can move
Only
in,
3 years imprisonment,
but
my
if you
lord.
can move in Guwahati with knife in the
My
arms.
lord.
No, my lord. I am a
No.
YouTuber by
Knife is
profession,
used,
my
my
lord. I am the car owner, my lord. I was
Whatever
inside the
has
car,
happened,
my
no.
lord. Some of my friends were
You see, Mr. Paramanik,
my lord.
in the morning when I come to court, I don't read newspapers.
My lord.
I may be influenced by whatever news reports come, therefore I don't read it. But definitely in the evening, I read the newspapers. So this came out about a week back
My lord.
in the newspaper, and therefore, once we read that you are
But fact
moving
is
in the,
that, my lord.
and you are assaulting a what do you call vegetable vendor.
My lord, my friends assaulted.
No,
my lord,
whatever happened.
Involved,
No.
involved into the quarrel, my lord.
Not if you come in a vehicle and assault a vegetable vendor. No.
My lord, actually, we are going
No,
to
whatever happened.
shoot
No,
some video, my lord.
Case diary on
My lord,
15/7/2025.
because so far as this section, my lord, no such serious injury or grievous injury.
It's not of that.
My lord.
It's not a question of that.
My
But
lord. So, my lord, kindly.
to assault a small vegetable
Then, my
vendor.
lord, during my lord vacation, my lord, from this my lord.
No.
My lord, vacation court, kindly.
Vacation, then we, what do you call, because I won't fix a matter in a vacation court. You'll have to make a request or prayer before the same honorable judge before whom we want to make it. By judicial order, I'm not fixing any matter in any vacation bench.
My lord. Hallelujah.
And these orders would not be a bar for the entertaining of a prayer before the vacation bench. It will depend on the honorable judge. Yes, item 6.
Hallelujah.
Yes.
FIR is at page 24, your lordship.
20?
24, your lordship.
Oh.
By a manager of a hotel, your lordship. So far as the demand part is concerned, your lordship, that is absolutely false, your lordship. So far as the other part is concerned, your lordship, there is an altercation that had taken place, your lordship. We have booked your lordship room, your lordship, for our guests. We are organizing a Rongali Bihu, your lordship, that I have annexed, your lordship. And they have, your lordship, sold it to someone else who could not get it. There is an altercation that is there, your lordship. And finally, your lordship, when they lost this affair, your lordship, they have put this also so that it become non-bailable offense, your lordship. This is the case, your lordship. And I have narrated my incident, your lordship, and para 6, your lordship, of my petition, what has actually happened. I have admitted that I had gone there, your lordship. Probably, your lordship, custodial interrogation may not be required, your lordship. Your lordship may call for the case there. In the meantime, your lordship, I will cooperate with the investigation, your lordship. Para 6 is my story, your lordship, of the petition. 2008 and 9th May 2025, your lordship, the Rongali Bihu celebration was there, your lordship. Incident is also of the night of May 8, your lordship. Alleged incident, your lordship.
Call for the case diary.
Yes. In the meantime, if your lordship can protect your lordship, we will cooperate your lordship, and if your lordship
No,
find-
because they say in the FIR that there's a video evidence also available in the CCTV.
lordship, that your lordship will ultimately CD will break. With CD, everything will come, your lordship. Therefore, your lordship, if your lordship finds something in the CD, your lordship will, the petitioner will face the consequence, your lordship, ultimately. I leave it to your lordship. We are there, your lordship. I have not denied that, your lordship, on that night.
Yes, Mr. Bashir.
My lord, allegation is, my lord, serious, my lord, at the night hours, my lord, and regarding the privacy part of the, my lord, that is the, those who are there, my lord, that is also
Not
mentioned.
very.
Privacy, your
Used to
lordship.
be.
The allegation is serious, your lordship. I don't deny that, your lordship. But sometimes, your lordship, allegations are, your lordship, made to be serious, your lordship. And your lordship will kindly see this second paragraph. They say that police is also present, your lordship.
Yes, that's the
Whether
reason why,
that can happen, your lordship.
that's the reason we're stopping from or passing anything.
Lordship.
We said the police was present.
Lordship, that is what your lordship, when police is present in presence of them, your lordship, it is happening. It's just slightly doubtful, your lordship.
Not doubtful. Just discloses this part.
Either way, your lordship, we can see this, your lordship. But if your lordship, there is two, that's what it is. I leave it to your lordship, but your lordship, ultimately, in the end of the day, your lordship, custodial interrogation in this nature of case probably is not required, your lordship.
And
If
Mr.
it is-
Bhattakur and counsel for the petitioner, as well as Mr. K. Bushra, the APP for the state. Next, pending arrest in connection with page 2. So and so. The petitioner, namely so and so, is paid for PRS bail under section 482 CRPC, BNSS. Let the case diary be produced on when
Yeah, yes, that's better.
Well, immediately after vacation month, 15th.
23/7/2025. Next. Learned counsel for the petitioner has paid for interim bail, which is opposed by the learned APP for the state on the ground that the petitioner, having threatened the hotel staff of the informant, will also infringe the privacy of the guests staying in the hotel. And they also threatened the hotel staff and security personnel. Next paragraph. Considering the nature of allegations contained in the FIR, the court is of the considered opinion that custodial interrogation of the petitioner may not be required. So accordingly, the court is inclined to grant interim bail to the petitioner, namely so and so, providing that in the event of his arrest, bail of rupees 20,000 with one surety of like amount to the satisfaction of the authority. Amongst other cases, that other conditions shall appear before the IO within 7 days from the date of the order, should cooperate with the investigation. Next, in the event the petitioner is found to visit the property of the complainant or threaten the complainant or anyone in the management or staff of the said hotel. What is the hotel? Name of the hotel? The Conway Hotel, the Conway, CONVEY, Conway Hotel. It shall be open to the IO to inform to send a report to the Office of the Public Prosecutor, Assam at Guwahati High Court, for producing it before the court on the next date of listing. Next paragraph. The list on 27 for case diary. If you visit there or threaten, then
Lots.
we are asking for a report.
Lots.
On the
Lots.
8, item 8.
This is also your lordship anticipatory bail application, your lordship.
FIR.
FIR will also get it at page 12, your lordship. There are 3 accused, your lordship. One is before this honorable court.
For the call to the case diary here.
Yes.
The case diary produced on from which place?
Your lordship.
Silapathar.
Silapathar.
Yes, Mr. Bushra.
My lord, 16, my lord.
16.
16.
Okay, 7/2025.
Deep jump.
Item 9.
Yeah, please, Your Lordship. My lord, 482 application, my lord. The FIR at page 11, my lord. The translated copy, my lord. The allegation is, my lord, under section 103, my lord. But the allegation, my lord, directly specifically mentioned against the accused number 1, my lord. In the FIR.
We'll
Particular
call for the
address-
case diary.
My lord, other are not involved, my lord.
We don't know.
My lord, the specifically, my lord, the allegation indicated that the accused number 1, he committed the offense, my lord.
No, whatever be, but we'll have the case diary.
My lord, there, my lord, my lord, I have, my lord, stated the crux of the case, my lord, at para, my lord, 5. There were, my lord, gathered more than, my lord, 200 persons. And there were 2 groups, my lord. And
We don't know about that.
what
There
is
was
the
somebody
split
somebody has
between two
died.
Groups, my lord.
Somebody has died. Is it right?
Yes.
Somebody has died.
That is correct, my lord.
No.
My lord,
You're not protecting anyone. Let the case diary be produced on. This is
16,
from
my
which
lord.
place?
16, my lord. Oh, Nalbari, my lord.
Nalbari,
Nalbari.
16.
16.
720, 16, 725.
my lord, can it be on 15, my lord?
They'll not be able to get it. They'll get only one
My
day
lord.
in between. You can get it on 15th.
No, 15.
Okay, 15th. Make it.
15.
Yes.
Item 11.
11.
Lord,
Yes, which page is the
bail
FIR?
application, my lord.
FIR page.
My lord, FIR page, my lord, 15, my lord. This is civil in nature, my lord.
You call for the case diary. 24 tons of Erica nuts vanished.
My lord, we already filed in an FIR, my lord, page number 17, my lord.
This is different. One is for check, one is for something else.
But then for the check, they could have filed NI case, my lord.
We don't know about that. It's not for that FIR. The FIR has been filed. Paragraph 7 says the current fact is 12/5, 24 tons of Erica nuts was transported, was suddenly mysteriously vanished.
Yes, my lord, this vehicle which was missing since last year, they got it now. After 1 year, they filed an FIR, my lord. After 1 year, in the meantime, my lord, the petitioner was just the facilitator. One Pradeep Gogoi, he was the main person.
We don't know. Once it's a huge quantity of 24 tons of Erica nuts.
Who showed our bona fide by filing an FIR, which is in the next page 17. I'm just pressing for an interim, my lord.
No.
Under pressure, he signed some check and the check was bounced. They could have filed an NI case. my lord. After a year,
What they
came and
could
filed
do,
an-
we don't know, but it's a case of loss of 24 tons of Erica nuts.
There is transaction of money between the informant and the main person who arranged the vehicle, Pradeep Gogoi, my lord, which is page 21. I was just the middleman,
Let it come. It's
my lord.
21. This all is scan copy of FIR, case diary here also. With the scan copy of the case diary. Produced on
Sri Bhumi, my lord, Badarpur, yes.
Mother, when?
18, my lord.
18/7/2025. Mr. Bosho.
My lord.
We are not putting it in the order.
My lord.
Because it will be. We don't want to put it in the order, but specifically when you ask for the case diary.
My lord.
You also ask whether e-way bills with regard to the Erica nuts were there.
My lord.
Whether there was any e-way bill for transportation of the Erica nuts.
My.
Get this information specifically. So this is item otherwise covered by GST.
My.
Whether it was there or not.
GST was paid, my lord. It was paid. GST was paid.
No, whatever be, then we understand the transaction.
My lord.
Item 12.
12.
My lord, this is charge-sheeted case, my lord. 12. Here, my lord, FIR at page, my lord, 16, 16, my lord. My lord, I am for accused number 1 and 8, my lord. Charge-sheeted case, my lord. The case is pending before the Chief Judicial Magistrate. And my lord, they could not appear, my lord, due to embargo, my lord, embargo of section 481, my lord. My lord,
which provision?
There, my lord, 480, my lord. DNS.
What 480 of BNSS?
Yes. 480 Roman 1, my lord.
What is the embargo here?
My lord, embargo here, they, my lord, they could not appear, my lord, because, my lord, the allegation, my lord, against them, my lord, punishment for life, my lord. And they are, my lord, ready
Please
to
choose your
face
words
the trial.
carefully. Please choose your words carefully. Is it an embargo? You unnecessarily made me read this provision.
And my lord, the case is not yet committed, man.
That's okay. But now what do you want here?
They are, my lord, they agree to face the trial, my lord. They want to appear before the trial.
Oh, we are not giving you that protection. In case this is a murder, somebody has died.
My lord.
No, we are not protecting you.
Our accused person, my lord, the case is not, my lord, proceeding. Because of, my lord, this.
We are not protecting you even for a minute.
And they were declared absconder, my lord, without following the due procedure of law, my lord. My lord, only a direction to appear them, my lord, before the trial court, and trial court will consider.
We'll give you, we are not giving you any protection.
My lord, on the other day, my lord, the coordinated bench, my lord. Similar situation, my lord.
In 103, in office of 103.
That
You are
is, my
granting.
not one.
This was this order.
489. That's. My lord, the allegation is, my lord, different, but similar nature, my lord.
Very well. Now I'll give the vote to the power of vote to the learned counsel sitting here. This is a case of
My lord.
forfeiting, what you call counterfeit notes. He said that counterfeit notes and murder is similar,
No. Nature, my lord, similar nature. So
similar
the-
nature.
In this case also, my
Okay.
lord, the charge sheet.
We are dismissing our petition right now.
Submitted, my lord. And
We are,
they desire to appear before
We
the
are-
trial court. And in my case.
we are,
also,
you see, we are expressing our gratitude by dismissing our petition. Heard Mr. S.A. Ahmed, and Counsel for the Petitioner,
my lord,
and
this
Mr. K.
can be
Boishal and
very
APP for the state.
This can be made also.
Mr. Ahmed, never tease a person who can write by both hands. I can
My lord.
write by both hands. Never tease people like that. You won't even know what is to fall on you. By filing this application under section 482 CRPC, BNSS, the petitioners, namely so and so, are applying for PRS bail in connection with Sorbok PS case number page 1. Next para. As per the contents of the FIR dated 8/8/2024, the FIR named 9 accused persons had attacked the sister of the complainant with regard to a land dispute which resulted in the death of the complainant's sister on spot. Full stop. Next paragraph, the learned counsel for the petitioner has submitted that in view of the provisions of section 480 of the BNSS, it requires that the committal court would take the accused into custody and send him to the sessions court, the petitioners did not appear before the committal court. Full stop. Next paragraph, the learned counsel for the petitioner has produced a copy of order dated 24/2/2025, passed in AB 386 of 2025, which relates to offenses involving counterfeit notes under section 489 capital B and 489 capital D of the IPC. And it is submitted that the offense is similar where this court was pleased to grant PRS bail to the petitioner, to the petitioners in that case. Next paragraph. The ground for seeking bail, seeking PRS bail by the petitioner cannot be acceded to because of the fact that in this case, on an attack made by a group of 9 persons, it seemed resulted in the death of the sister of the complainant. And therefore, the court is not inclined to bypass the provisions of section 480 of the BNSS in light of the nature of offense committed by the accused by the petitioners, offense of which the petitioners are accused. Next para. Accordingly, the prayer for bail is rejected. Item 13.
Item 13.
May it please your lordship.
Yes,
Page 10 is the FIR, your lordship.
page 10.
Page 10, my lord. But my allegation is at page 11, my lord. Page 10, my lord. Regarding the preparation of a fake sale deed, my lord. And my allegation is that, my lord, I have, my lord, not, my lord, done field verification as I am the Lat Mondal, my LRA, and Land Revenue Assistant, my lord. Page 11 is the allegation against me. So, my lord, first of all, my lord, if they say, my lord, that the.
Just 1 minute, Mr.
Lord,
Abdullah.
I'm sorry, my lord.
No, it's okay. I'm just reading it. Yes, Mr. Abdullah.
My lordship, now, my lord, they say that the sale deed is fake, my lord. But when they, first of all, when the sale deed is fake, my lord, the question of my verification does not arise, my lord. And my allegation is that I have not done field verification, my lord. That is at page 11, my lord. So, my lord, at this stage, I'm a LR, I'm a Lat Mondal, my lordship may protect me, my lord, I'll appear, my lord. In preparation of the deed, my lord, everything, or I am not. Allegation that I have not done field verification of the lot. And lordship, registration of a sale deed, my lord. Field verification of a Mondal may not be required, my lord. Well, now, they are saying that the concerned sale deed is fake one. So if there's the fake one, nobody approached the circle office, concerned circle office for field verification, my lord. So when they say it is prepared, manufactured one.
Is there
Lordship.
any other document?
No, my lord, the sale deed I have annexed, my lord. There's no other documents, my lord. At this stage, man, I pray, my lord, lordship may protect me, my lord. I'm a government employee, my lord. Only allegation is that I have not done field verification.
Yes, Mr. Bashir.
My lord, here, my lord, this is the FIR is lodged by the circle officer,
Circle
my lord,
officer.
concerned circle officer. And my lord, the last part, my lord, where he stated, my lord, additionally, it is pertinent to mention here that the complainant had mentioned the name of so and so. In the inquiry, it is found that the name of the present petitioner, Mr. Kamal Sharma, and other one, were involved in the dubious activities.
And moreover, when a case relates to documents and documentary evidence, my lord, for which, my lord, custodial intervention at this stage may not be required, your lordship. I'll appear, my lord, I'll cooperate, my lord. I'm a government employee, my lord. There is no chance of absconding also.
Something is missing in this FIR.
The original one, my lord, is at page 15.
No, we have seen that. We have compared it.
No.
But there's some sequence which is totally missing. I've compared it in the meantime. That's why I stopped you for a moment.
Lordship.
I had an impression that there's certain things missing in this FIR. That's why I
Lordship.
cross-checked your page 10 with page 15. Because Mr. Busho,
My lord,
we find some force in the submission of Mr. Abdullah.
my lord.
A lot bundle will not go to a plot just like that. He would go there only if there is any mutation case pending.
My lord,
They don't say about that.
my lord.
Otherwise, there is something which I find missing. Why would a land revenue assistant go in the first place to establish position? There must be some case registered.
My lord.
That case is not mentioned here. That is the missing part. If it is a proceeding under proceeding for mutation, if it is a proceeding for what do you call demarcation, we could have understood.
Yes, my lord, because it is field verification regarding the demarcation. Only, my lord, the last part, it is stated that additionally it is pertinent to mention.
No, but why will he go there?
My lord, but that is
missing
also
part
right.
here. He gives some protection to Mr. Abdullah
My
for the
lord,
time being.
my-
But Mr. SM Abdullah and counsel for the petitioner. And Mr. K. Bushel and APP for the state. Apprehending arrest in connection with page 1, Jaklabanda PS case number so and so. Where for previous bail. And section 482 CRPC, BNSS. Is diary produced on a scan copy of the case diary? Shall be produced on? Yes.
It is from which place?
Jaklabanda.
Nagaon, my lord. So, my lord, 23, my lord.
23/7/2025. Prayer for interim bail for the interim PRS bill for the petitioner is opposed by landed APP for the state. We noticed that the petitioner is a land revenue
Assistant, my lord.
assistant. And there's no indication in the FIR as to why the field verification was required, which was not done by the. But don't say everything. Just say the contents of the FIR and taking note of the fact that the petitioner is a land revenue assistant and therefore a government servant, comma, the court is inclined to grant interim PRS bill to the petitioner, namely so and so. Condition of 20,000 with one surety of like amount to the satisfaction of the vesting officer. Petitioner shall appear before the IO within 7 days from the date of the order and shall cooperate with the investigation. Based on so and so.
Oblige your lord.
Item 14.
Yes, you got the information. Mr. Barwa.
My lord, he is the authorized agent of the market committee, my lord.
He's
The
the authorized
market
agent.
committee, my lord,
Understand.
and my lord, he sustained injury, my lord, he has been hospitalized, my lord.
Then you
My
call
lord.
for the case diary.
Yes, my lord.
You are not giving you interim protection. This is that matter Mr. HRH Churi moved yesterday, right?
Yes,
Ah,
yes,
okay.
yes.
And Mr. MQ sent and counsel for the petitioner. Next, pursuant to order dated 25/6/2025, Mr. RJ Barwa and an APP for the state has submitted that as per instructions received by him, comma, the victim is a authorized tax collector of Sonai Municipal Board. Next, paragraph. Accordingly, court is inclined to call for the case diary. I want to scan copy of the case diary, injury report if any. list on. This is from
Sonai
Sonai.
Kasar.
Kasarman.
Sonai Salmara.
Kasar, Lord.
18th, then get it. 18/7/2025. Item 15.
My lord, in this
Item
case,
15.
Yes.
my lord, in this case also, my lord, lordship has asked to inquire, my lord, whether any cases pending or not, my lord. We have received the information, my lord. A case has been registered, my lord, as a CID case number 4 of 2025 under section 61(2), 3184, 336, 342
Just one minute.
BNSS, my lord. Now, my lord, as per the FIR, my lord, he has been not implicated in the FIR, my lord. But
Just-
during investigation, my lord,
Okay.
police has come to know that, my lord, he is also involved, my
No,
lord.
but after these Supreme Court judgments, you have to call this them by issuing a notice. Why notice are not being issued?
Notice probably, my lord, it is not given or not, but that will even from the, my lord, case diary, my lord. 41 and
As per
notice.
the instruction
Okay.
received, my lord, we have not
We'll
received
call for the
any.
case diary, we give them interim protection then.
So then my objection may be recorded, my lord.
Yes. But Mr.
AV Singh.
AB,
AV Singh.
AV Singh, learned counsel for the petitioner, as well as Mr. RG Barwan, the AV for the state. Next paragraph. Pursuant to order dated 25/6/2025. On the learned APP has submitted that as per instructions received by him, comma, during an investigation carried out by the CID, they require they required to examine the petitioner. Next paragraph. By filing this application under section 482 of the BNSS, the petitioner who is apprehending arrest in connection with a case registered by the CID, of which he has not received any notice. The present petition is the present application has been filed under section 482 of the BNSS. Next paragraph. That the case diary, that the case diary relevant to the case against the petitioner be produced by the CID, scan copy, with provision of this day of listing. Next paragraph. Here for interim bail of the petitioner is opposed by the learned APP. On the ground that if the CID is investigating a case, it must be presumed that they are serious in nature and may involve fraudulent transactions. And therefore, it submits that the prayer for bail may be considered on receipt of the on the perusal of the case diary. Next paragraph. Considering the projection made in this application that the petitioner was called by the CID personnel on his phone instead of issuing any notice of appearance. The court is of the considered opinion that pending perusal of the case diary, as an interim measure, the petitioner be granted a pre-arrest bail. Accordingly, it is provided that in the event of arrest of the petitioner in connection with this aforementioned case, arresting officer shall release the petitioner, namely so and so, on is furnishing a bail bond of rupees 30,000 with to surety of like amount to the satisfaction of the arresting officer. Next one. Interim bail is granted on following conditions. The petitioner shall appear before the criminal investigation department of the state. Along with this, along with one advocate, comma, if so advised. The other conditions are there. Next list. List on
28/7/1.
28/7/2025.
Item 16.
Lordship, that is page number 9, your Lordship.
Page number 9.
Yes.
We call for the case diary. Did the case diary be produced on? Just from which place?
Records, Lordship, from,
Charge sheeted case.
yes, Lordship. From Learned Court of Judicial Magistrate, first class, Dibrugarh, Lordship.
Okay. The registry shall call for the scanned copy of the case records of. Where is that number?
Page number 1, PRC case number 119/2025.
No, where is it written?
Lordship,
From where will I find that number?
Lordship,
In your
is
petition or
in the post
document?
title as well as in the petition, your Lordship.
Where? Just show me so that I don't make a mistake in the order. Otherwise, we
Lordship, there are two, page number 2, Lordship.
there are two, page number 2. Okay. Records of PRC case number 119/2025 under section 64 of the BNS corresponding to Barbarua, BARUH, Barbarua PS case number 97/2024 within bracket GR number 1189/2024 from the Court of Judicial Magistrate, first class Dibrugarh. Next para. The requisition may be sent through the through email with liberty to the said learned court to send a scanned copy of the records through email or being placed before the court. Next para, list on 21/7/2025.
Item 17.
Not legal, Lordship. First page 7.
Page.
Page 7. Start from page 7. In this case, Lordship, there is a cross of hair also, Lordship. And it is a land dispute, Lordship.
Attempt to murder and give you a third one.
Land dispute, Lordship, I have annexed one order.
Okay.
No,
We'll call for
just
the
in your
case diary.
division, Lordship. Page 12.
We'll have to call for the case diary.
Page 12, Lordship, I have annexed an order also, Lordship. From
So
Superior
that's
Division.
okay, but once you have,
Both sides, Lordship, got serious.
so that's okay. Let the case record, let the scan copy of the case diary be produced on, this is from which place?
No comments.
Nagaon PS, Pipaihat. Pipaihat will be 18th, you can produce it? Mr. Barwa,
My lord.
18th,
Yes, my lord.
18/7/2025.
Apply.
Item 18. Quashing of FIR. Okay, we are issuing a notice.
What happened in this case, Lordship?
We are issuing a notice at this stage. We are not staying the proceedings.
Lordship, off late, Lordship, there is a second officer and he is harassing me. We are employees in the Nerim, Lordship, both husband and wife. We are working in the area and we are, Lordship, whenever he calls us, we go and appear. Lordship, Lordship may kindly see the bail order, Lordship. This is already a civil title suit is pending. And he has also appeared and he has filed his WS, the informant. Lordship, the petitioner, Lordship, she had applied for partition of a particular land in
No,
the,
that's
in the
okay,
under the Right to Public Service Act.
No, whatever be.
Lordship,
But you are on bail.
I am on bail, Lordship.
Then
Because, Lordship, since we are in, Lordship, working in Meghalaya, Nerim, Lordship, he frequent, Lordship may kindly see, another order has been issued that has not been part. Frequently, Lordship, he is calling us, Lordship.
release the notice to call you.
I am just pressing it. And also our bail order has also been made absolute. Because this is the civil nature. And a criminal color has been given.
But once you get a notice, we'll have to go. Can we?
Already we have appeared, Lordship. After, then again.
Sorry, Mr. Das, we don't know of the procedure that the IO will have to conclude the questioning on one day.
My Lordship is very correct.
This is something we don't know of.
Your Lordship is correct. But Lordship is
We are not staying.
Then
At this stage, we are not staying unless we look at the scanned copy of the records and then we've asked for questioning of the FIR. It's not the questioning of the what you call stay of the investigation.
No, I'm not asking for
Questioning of investigation, we can't stop. So by refraining the police from inquiring, it will be a stay of inquiry, which they can't do.
Lordship may kindly give some orders, no coercive action.
Oh, coercive
That
action,
is not
let them,
required, my lord.
let them arrest you, then it will be a coercive action. Let them do it after the bail order you got, let them take coercive action. Why you are apprehensive? Let us do some work. Once we get information that I fought on bail, no, we can't stay investigation. Just issue a notice. We can't stay the investigation. Heard Mr. S.K. Das, non-counsel of the petitioners, as well as Mr. R. Barwal and the VP for the state. Next, Barwal. The petitioners, by filing this application under section 528, read with section 442 of the BNSS, is prayed for quashing of the Swalkuchi PS case number 127/2024, corresponding to GR case number 545/2024 under section 318 for this page 1. Tagged it. So, next problem. As well as for questioning of all the orders passed by the which order you asking for quashing? Mr. Das, which particular order you want quashing of?
No, it is an investigation stage.
Stay of the FIR, man.
Stay of the affair.
Investigation, man.
No. His page 1, second cause title is quashing of all orders passed by the judicial magistrate. So what is the order? You want quashing of the bail order?
Page 1 of
Page 1.
Which order you want?
Oh, my synopsis.
No, not synopsis. Your petition page 1.
Prayer.
page 1 of your petition, just open it up, your cause title.
I'm setting aside of quashing of all orders passed by the judicial.
What order?
Oh, lordship, that is a mistake. That is in the investigation stage. That format, lordship, it has come.
No, we don't know.
Effect of copy paste.
That-
No, we don't know. At least Mr. Das cannot say that the court has not read my petition.
Lordship, but lordship, the essentially it is a lordship civil dispute, lordship.
No, it's okay. We are not saying anything. Then you add setting aside of case number, the FIR. Yesterday, as well, your case number, so. Has charges been framed or explained? Charges has been framed or explained? Or has a committal order been passed?
Not yet frame, lordship.
Committal order has not been passed.
No.
The land counsel for the petitioner has submitted that the dispute between the petitioners and the respondent number 2 is essentially civil in nature, for which civil suit is also pending between the parties. Next paragraph. Submitted that the IO of the case is frequently calling the petitioners for investigation. Next paragraph. Issue notice returnable on 1/8/2025. The petitioners shall take steps within
Yes, number 2.
27/6/2025 for issuance of notice on the respondent number 2 by registered post with AD as well as through usual process, which is to be routed through the jurisdictional magistrate for being served through the judicial magistrate to be served to the respondent number 2. Next para. You've got copies, you don't need extra copies, Mr. Barwa?
No, the copy has already been served.
Yes, sir. Okay. Next para is the investigation is at nascent stage. And on a query made by the query made by the court, the learned counsel for the petitioner submitted that the charge sheet has not been filed in the case. Rooting down. On a query of the court, the learned counsel of the petitioner submitted that charge sheet has not been submitted in this case. First of therefore, the investigation is in nascent stage. So accordingly, at this stage, the court is not inclined to stay the FIR, which was result in suspension of the investigation. Next paragraph. The second interim prayer made by the learned counsel made in this petition is to restrain the to restrain the police personnel to take any coercive action against the petitioners. Come on. Having noted that the Court of London Additional Session Judge, by an order dated 16/11/2024, passed in AB 537 of the 2024, has already granted anticipated bail to the petitioners. No further orders required to be passed on the second interim prayer. Next paragraph, based on 1/8/2025.
Item 19.
May I please, my lord? My lord, last time, my lord, as per honorable court may required, my lord, custodial warrant, my lord, is available or not in records, my lord.
Yes.
That report has come, Lordship. That is not available in the.
Pardon me?
That report has come, but it is not available in the HCR, Lordship, as per report, Lordship.
Then Mr. Laika will have to grant bail to the petitioner.
Lordship.
If there is no custody warrant, then he's not informed of the reasons of arrest.
That's
So he'll entitled to bail then.
Because I was arguing on the custody cases, Lordship, wherein it is stated, Lordship, the warrant has to be read before him, Lordship. That will start
will
the
be
purpose,
over.
but if
So
it is not there, Lordship, then
That argument will not.
that will not come.
Okay. Heard Mr.
Yeah, Dr. my lord.
A.
Dr. my lord.
Datta and counsel for the petitioner, as well as Mr. P.S. Lakar, learned additional learned APP appearing for the state. Next paragraph. The petitioner is in custody since 6/12/2023 in connection with special within bracket N bracket close case number 7 of 2024, arising out of GR case number 4 to 9 of 2023 is page 1. Under section 20, this is 20 capital C or small c?
Capital C.
20 capital C oblique 29 of the NDPS Act, which is pending for disposal before the Court of London Special Judge Tarang Mangadai, has paid for bail under section 483 of the BNSS. Next paragraph. The learned counsel for the petitioner is submitted that the petitioner was arrested in connection with Masbat PS case number 70/2023 under section 20 within bracket small b bracket close within bracket small Roman 2 bracket close again bracket capital C bracket close public 29 of the NDPS Act. And the petitioner was shown arrest in connection with special within bracket N bracket close case number 7 of 2024. Is it right?
That's it.
He was arrested in Masbat
That's it.
first, correct?
That's it.
And then he's being shown arrest in special N case.
That's it.
In special N case 7 of 2024. Next, by the learned counsel for the petition has further submitted that the grounds of arrest was not served on the petitioner, and therefore he's become entitled to bail due to non-compliance of the provisions of section 47 of the BNSS. Next paragraph. The learned APP has opposed the prayer for bail on the ground that as per order of the learned special judge Darang, Mangalday in connection with special within bracket N bracket close case number 7 of 2024. There is an order of shown arrest of the petitioner who was already in custody in Masbat PS case number 70 of 2023. So accordingly, it is submitted that once a custody warrant has been issued, the petitioner is informed of the reasons of his arrest, and therefore there is no further requirement of issuance or to serve further grounds of arrest. Accordingly, it is the prayer permit for bail is objected to by the learned APP. Next panel. This court by an order dated 24/6/2025 had called for a scanned copy of the custody warrant, if any, issued by the learned special judge Darang Mangalday in respect of the petitioner, pursuant to order dated 6/12/2023, passed in Sipajar PS case number 101 of 2023. Upon requisition being sent, the learned special judge not you make it bracket and then say in charge. Right, close Darang Mangalday. Where a communication dated 25/6/2025, sent through email, which has been placed before the court. On search of the record, no such custody warrant was found. And accordingly, it is submitted by the learned special judge that hence it appears that no such warrant was issued against the petitioner dash accused. Next part. As the petitioner is not found to have been served with either the custody or the copy of warrant and oblique or custody warrant for being shown arrest by order dated 6/12/2023. In connection with special within bracket N bracket close case number 7 of 2024. Arising out of GR number 429 of the 2023, while he was in custody in connection with Masbat PS case number 70 of 2023. The court is of the considered opinion that the petitioner was not served with the ground of arrest, showing him arrest in connection with special within bracket N bracket close case number 7 of 2024. Next, accordingly, the court is of the considered opinion that the petitioner has become entitled to bail following the in view of the decision of the Supreme Court of India in the case of, what was that case?
My lord, Bihan Kumar.
I was
Bihan
arguing,
Kumar.
Yes, Bihan Kumar.
so I was arguing on Kasireddy lordship because as per the Kasireddy cases lordship, wherein it is opined lordship that lordship when there is a warrant that has to be read out.
Yes,
But
just give it to me. I forgot to have it here. Because Vihan Kumar versus
State of Habeas.
State of Haryana. So. Vihan Kumar State of Haryana. You have the decision. So.
Bihan Kumar is something contradiction. There is a contradiction that been also in Bihan Kumar and Kasireddy lordship. Bihan Kumar says lordship 47 has to be complied with by way of written ground of arrest. But Kasireddy has stated lordship that lordship it has to be.
Got your statement.
Written.
Vihan Kumar so. Next paragraph. Although the learned ABP has submitted by referring to the case of the judgment of the Supreme Court of India in the case of Kasireddy, KASI REDDY, Upender, 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 Reddy, REDDY, next word. Kasireddy is one word versus state of Andhra Pradesh and others. That if a person arrested is on the basis of a warrant, the reasons of arrest need not be separately served on the petitioner. First of, however, the ratio of the case of Kasireddy, Upender Reddy within brackets would apply only if the warrant of arrest was issued. First of, however, in view of the report sent by the learned special judge within bracket in charge, Darang Mangalde, there is no record of custody warrant in record. Court is inclined to release the petitioner, namely so and so on bail on his furnishing a bail bond of rupees 1,50,000 with 2 surety of like amount to the satisfaction of the learned special judge Darang Mangalde, to stop out of the two surety, public bailer, one should
Done.
offer his immovable property as surety for grant of bail having value of more than the bail amount for which the bail bond should be accompanied by the valuation of the property. Full stop. The further conditions of bail are that it will appear in each and every date fixed for trial. And in the event the petitioner cannot appear on any particular date of trial, I would ensure that he is duly represented by his learned counsel, duly instructed to cross-examine any witness that may be present, and no, the petitioner shall, next paragraph, the petitioner shall also submit a bond that no prayer for adjournment could be made on the ground that his instructions were not available to the learned counsel representing him during the trial. Next, in the event of any defaulted the petitioner in appearing before the trial court, would be open to the said learned court to treat this bail order as having lost its force, and it would be open to the learned special judge, Darang Mangalday, to issue warrant and to take the petitioner into custody for the remaining part of the trial. Other conditions are there. We are turning back here, Mr. Thakur.
DP only.
Item 20.
Today, look, time is very short, my lord. Here, my lord, by first order, I was not furnished ground of arrest, my lord. So report was called out. I have also annexed the notice, my lord, page 30, under section 50. Page 28, my lord, under section 50. Here is also no ground of.
Just.
Then page 28, first notice.
Then also you'll have to get a report from the, we've received this scanned copy of the record.
Yes.
But
Section 50 notice is there also.
is there.
Section 50 notice is there also.
But no ground of arrest.
But my submission will be lordship, on last occasion also I have started my submission with the AK Gopalan case lordship. And wherein lordship, it has been open in the case lordship that in para 350, AK Gopalan case, para 350 lordship.
Just a moment, let me see that section 50 notice.
I was also annexed, my lord, that is page 28 of my petition.
No, did you, Mr. Lekar, what we are asking is, did you confirm with the APP that this record is notice is not there in the record?
I didn't say again.
No, because you see what happens is that at the time, that's why the last occasion also in this case, we required you to have a checking with the APP so that if a document is there and missed out, the scanning, that's why we want that you should make an inquiry as to whether either from the IO of the case or from the peer review officer. Last time we Last time we have said that.
We can check it, Lordship, in
No, no, whether this is complete or not, we don't know. You get the point. You see,
Lordship.
supposing I scan 20 pages, I may miss out one. So last time, I think yesterday I passed out.
Yesterday, Lordship. Yes.
We want a confirmation that the purview officer has checked the records and they have not found this document, because we are releasing people who are accused of very serious offences. We want you to have a confirmation through either the APP
Lordship.
or through the purview officer or through the IO that this ground of arrest was not furnished. Then we'll take a call.
In one case, madam, I have found, madam, the ground of arrest was not in the scale UPB record, madam. But when the madam, the accused person was put before a trial court, madam. So there is an order that madam, ground of arrest has been submitted.
No, it may happen because we have seen that.
Then we call for a report, madam, then ultimately it came.
No, that's why. Because I have an experience with that. That's why we are asking you time and again. Yesterday also we asked you.
I have the certified copy also.
No, no, no. I'm not disbelieving you. But the question is that when we are releasing people who are dealing with drugs and other heinous offences, just take some extra care.
Lordship.
Mr. M.R. Khandekar, counsel for the petitioner, refers to the scanned copy of the case records and place for bail. Next para. Although the scanned copy of the records received, privacy does not disclose the service of ground of arrest on the petitioner, however, as the petitioner is accused of committing an offence which is punishable under section 22 within bracket C of the small c of the NDPS Act. It is small c or capital C?
Here is small c, madam.
Small c of the NDPS Act. The court is inclined to direct the London APP, Mr. P.S. Lakal and the APP to either interact with the IO of Fakirganj PS case number 150 of 2023 as to comma and obligor with the PP oblique APP dealing with the trial of special case number 333 of 2023 arising out of Fakirganj PS case number 150 of 2023 pending before the London special judge within bracket additional bracket was Dhubri and obligor from the payee officer, if any appointed in the said court, just to examine the records and inform him as to whether or not the records contain the trial court records contain any document showing service of notice under section. Sorry, it's not grounds of arrest to the petitioner. Next para, the London APP shall send a scanned copy of the order, download copy of the order to the concerned authorities to get information. Next para, the matter stands deferred today. List on 15/7/2025.
May I pray, my lord, on vacation court, 30th of 7th?
Pardon me?
May I pray on in the vacation court, my lord?
Vacation, no. I am not fixing any matters before vacation court. You make a mention before that court. By judicial order, I am not fixing any matter before vacation court.
Then, my lord, 15/7.
15 we are
So
making.
can it be officer in charge in place of instead of IO, because
IO,
IO senses
IO maybe not there. Okay, officer in charge of
the
Fakirganj police station.
Fakirganj piece.
Fakirganj police station.
My lord, it will be list 15/7.
15/7.
I am the.
22,
In my lord, I'm also seeking my lord bail. Non-foundation of ground of arrest.
Here also it is drugs.
Yes, that's my lord.
You're getting the same information.
Yeah, my lord, arrest memo you have annexed. The certified copy also I have obtained, my lord.
No, it's okay. We have to verify because we are relying on a scanned copy of records. This experience shows us many things.
LCI is also available, my lord.
Hmm?
LCI.
It's a scanned copy. We did not bring the original copies, therefore we have to verify.
We have obtained on the original certified copy.
No, we are not disputing what you are presenting, but we have to verify from the record. If it's not there, then it's not there because it's NDPS cases.
But
Mr. FKR Ahmed, learned counsel for the petitioner, the same order. This will be from Court of Learned Special Judge Shankardev Nagar Hojai. Case number is NDPS case number 93/2025, arising out of Lamding GRPS case number 18/2024 under section 20 within bracket small b within bracket small Roman 2 again bracket small c of the NDPS Act. This is pending for trial. The Special Judge Shankardev Nagar Hojai. Same order. Same date, 15/7.
Twenty-three,
Please, your lordship. With this my lord, I'm praying for modification of two bail conditions, my lord. Lordship, while releasing me on bail, had initially imposed two conditions, my lord. In addition to other conditions, initially the condition was that I should not leave the jurisdiction of the Kamrup Metro, my lord, and that I shall appear before the investigating officer every 15 days, my lord. Thereafter, that was modified, my lord, in April 2023, where as I am a resident of Kachar, my lord, your lordship required me to appear before the investigating officer every 45 days. Since then, I have been continuously appearing, my lord. However, there is no, my lord, I'm not being interrogated now, my lord. So I'm praying, and also I'm 67 years old, my lord, and it's a little difficult for me to keep coming all on every 45 days. So I'm praying, my lord, that I may be that condition may be removed, my lord.
Okay, you may interact with the IO and tell us. We'll take it up on the opening day. Mr. S. Dale and counsel for the petitioner, as well as Mr. P.S. Lakal and APP for the state. Next paragraph. By filing this interlocutory application, the petitioner was granted bail by order dated 25/1/2023, passed in BA 11/2023 in connection with crime branch PS case number 3/2022 under section
120B.
Just a moment. Page 4. On certain conditions, as prayed for modification of the conditions, relating to appearance of the petitioner before the IO. Next paragraph, the Learned Counsel for the petitioner has submitted that the petitioner is the applicant has earlier opposed this court by filing another interlocutory application for modification of the conditions, and this court by order dated 11/4/2023, passed in IA Criminal 280/2023, modified the conditions contained in the previous order by permitting the petitioner to physically appear before the investigating officer every 45 days till his personal appearance is dispensed with, charge sheet is submitted. Next para, the learned counsel for the petitioner has submitted that he has been attending the investigating officer every 45 days. So however, no intervention is being carried out during this time, these days, and charge sheet has also not been submitted till late, correct?
Lordship. that is
Charge sheet
my
not submitted.
Yes, my lord.
Next para, accordingly. For the state to notice to the London APP to inform as to whether there's any objection to the extension of period of personal appearance from 45 days, 90 days. Till his personal appearance is dispensed or charge sheet is submitted, as well as to inform whether the APP, whether the IO requires further personal appearance of the petitioner in the case. Next, para, the London APP shall send a downloaded copy of this order to the IO of
Crime branch PS case 3/2022.
Crime Branch PS case number.
3/2022.
Please say that again, 3/2022.
Yes, ma'am.
You are resident of
I'm a resident of Kachar
Kachar.
district.
Just say that. The modification is up on the ground that the petitioner is a resident of Kachar, and therefore it is inconvenient for the petitioner to travel a long distance for appearance. Specifically taking into consideration the present situation where there is recurrent flood in the state. Next para, list on 18/7/2025. We just need the modification instead of 45 days, if it's not really required, 90 days. Or alternatively, if appearance can be made by, no, I will not like video conferencing appearance.
Otherwise,
Well, Lordship,
notification come from Lordship side. Or notification come from Lordship side. I could release this side regarding see.
No, this can't be done.
Lordship, the IO may require me to come anytime, whenever required, I would appear, my lord. I'm ready to appear.
Oh, this alternatively, let's just make it a mechanism or to alternatively summon the petitioner as and when required by sending a summons to the email address of the petitioner to be disclosed. You correct the email address.
I will provide whatever.
Email address to which will be provided by the learned counsel for the petitioner. Okay. Nice, very nice.